having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month...
We're having fun.
All right. Hello, everybody. How are we doing? We are back today. Finally got a little bit of sleep. So there is a different trial that is starting on Monday with jury selection. And this one seems a little bit more interesting than the Alex Murdaugh trial. And I really kind of didn't want to have to restream for days on end. What's up, Sassy? So since this starts on Monday, it's great because it gives us time to do, a day of some background details about the case, and it gives me time to sleep and get things prepared over the weekend and all of that. So just a quick little background, and we'll get into the real juicy stuff, and we're going to play some videos today. Starting with basically the arrest of Aiden Fucci. So Aiden was a 15-year-old who allegedly brutally stabbed 13-year-old Tristyn Bailey. This is a Florida case. So this is out of St. Johns County, Florida. Now, this young girl was stabbed 114 times. 49 of those stab wounds are defensive wounds. So this is kind of a brutal murder. And she was found on Mother's Day. And he is being tried as an adult. He faces life in prison. He's not eligible for the death penalty because he was a minor at the time. And there's some interesting stuff because he is not getting a 12-person jury. He's only getting a 6-person jury. And there is a reason for that. But we'll get a little bit more into that in just a little bit. I'm gonna play, like I said, we're gonna play some videos. We're gonna dive into some case background. We'll play some pretrial hearings. Again, the case is slated to start Monday morning with jury selection. It does sound like jury selection will be televised. The defense had filed a motion to bar the media cameras from being in the courtroom for jury selection. And several media outlets showed up prepared to fight that motion. And the defense dropped their motion to bar the cameras. So it does sound like voir dire will be televised Monday morning. Expected to take 2 to 2.5 days, 2 to 3 days of voir dire. So we'll get more into that as well. But first, here we go with our first video.
Thank you for coming on short notice. We appreciate it. We feel like this information is important to get out. We're going to kind of regress a little bit and go backwards and kind of recap a few things from yesterday. We are going to take some questions at the end if we need to clarify a few things. I just want to kind of just backtrack where this incident occurred, when it occurred, and where it occurred. You remember yesterday at 10 hours or 10 o'clock in the morning, we received a call at our 911 communication center from Tristyn Bailey's family reporting Tristyn missing. We immediately went to work at the St. Johns County Sheriff's Office along with the community, and we verified that the last time Tristyn had been seen was last night or on Saturday night, early Sunday morning, just after midnight by her family members. Again, we went to a very extensive search, including our criminal investigation division, and also putting out everything we could think of to our media, putting out pictures of Tristyn, putting out anything we could think of. And again, that community really stepped up and got involved with us here at the St. Johns County Sheriff's Office. At about 6 p.m. last night, one of our residents actually, based on the information we were putting out, was actually out looking around his area where he lives and actually discovered what has now been verified as Tristyn Bailey's body in a wooded area. I apologize. Thank you for correcting me. Tristyn Bailey, and I do apologize. Tristyn Bailey's body that was actually located by a person in the neighborhood, a citizen in the neighborhood, and actually called 911, called the sheriff's office. We went out there and actually processed the body and recovered the body. Since then, we actually have arrested a suspect by the name of Aiden Fucci, F-U-C-C-I, 14-year-old. He's currently in custody with the Department of Juvenile Justice, charged with second-degree murder. Again, that second-degree murder case and charge came up with the corroboration of us, the Office of the State Attorney, and our investigative team. I will tell you this, this is a long process. We're in the very early stages of this. I think it's important that we actually put out that the suspect is in custody as we speak. There are no further threats to this particular case. And with that being said, again, this is a time for us to work with Tristyn Bailey's family to make sure that they have all the information way before you have the information. That's how we do business here in the St. Johns County Sheriff's Office. So again, I'll take questions here. Any questions?
Sheriff, there had been talk of possibly a second person involved. Is this definitively one suspect in this case, or was there any other witnesses or people around at this time?
That's a great question, but there's lots of witnesses. Again, we're in the very early stages. We're less than 24 hours into this entire case, a little bit over that as far as when it was actually reported. So that being said, our investigative team is out there interviewing all kinds of witnesses, whether it's indirectly or directly involved in this case. But as I told you before, we have a suspect in custody. That is the only suspect that has to do with the death of Tristyn.
Any known relationship between the victim and the suspect?
As you know, they're both attending the same school, or both attended the same school, which we'll talk about here in a minute, which is Patriot Oak School, which you know very well. I'm not going to say they were classmates. We have not verified that. Again, trying to give respect to the school as they go through their grieving process as well.
Did social media play a role? There's a Snapchat of Aiden, it's believed to be Aiden in the back of a squad car with a peace sign up saying, "Where's Tristyn?" Is that something that you guys are aware of?
Sure, absolutely. I will tell you this, our real-time intelligence center really have captured all these videos as much as we can. We monitor it, and unfortunately with some of these things that are actually, maybe you think is detrimental to the case, actually help us in the case and actually don't actually hurt the case because we're collecting this media, we're collecting this real-time. Again, and people have rights until they're charged with a crime. I think you all know that in this room.
We heard she was in a cheer outfit. Can you say where and how
Again, this is the very early stages of this. The family would get that information first. As I told you before, it was in a wooded area. She was clothed, as my investigative team will tell you. But as far as what she actually had on and stuff, physically the investigator process with the medical examiner's office is going on as we speak, and we're going to let them finish that process and make sure the family is informed of any findings first.
Did you have conversations
Go ahead.
between Aiden and her in the moments leading up to this? You know, how did they link up? There was talk from family that they saw her willingly leaving with her, with him and another boy.
Sure, again, I'm going to just caution all of our listeners out there today that just because it's on social media doesn't mean it's true. Our investigative team is collecting all those leads and processing those leads. And again, once we get the entire package together and her family knows first, then we will share it with you. Again, this was a day that we wanted to share with you that the suspect is under arrest. He's currently in custody with the Department of Juvenile Justice. He is charged with second-degree murder. We want to put our community at ease that we have that suspect in custody.
Why second-degree murder?
I'm sorry. Yes, ma'am.
Second-degree murder?
That is actually a decision that was made collectively, like I talked about before, with the state attorney's office. And that's one of those cases, too. We can always increase the charge. But as we spoke of this case last night, based on the facts we have, that's given time for our investigative team to continue to build a better and better case. We don't stop this process just because, I'm sorry, we got cut off. We don't stop this process of this case just because the suspect was arrested. This is a long process we have to go through. There's multiple crime scenes involved here, as you know. And with that being said, again, we're going to let our Criminal Investigations Division do their due diligence and take their time and get this case right.
Can you give us a cause of death? Can you give us a cause of death?
At this time, we're not giving a cause of death, but I will actually let Director Cole, if you want to add to that at all, I'll let you add to it.
No, there's nothing to add at this point. Their medical examiner is still conducting their investigation, and once that's concluded, we'll share that with the family, and then we'll decide on whether to share it with the media.
So as I told you before, too, I'll reiterate again, they're physically in the process. This is not an easy process for the medical examiner's office. We're going to let them, again, take their time, be very thorough, dot their I's and cross the T's. It's important. We have a person charged, with a serious crime, and we have a family that's grieving the loss of a loved one, a child, a 13-year-old child.
Any weapons found? Any weapons found on any of them?
Again, asking about weapons and clothing and stuff, we're in the very early stages. We're just over 24 hours in the beginning of this investigation. And in order for us to do some accurate interviews with a lot of people that are still out there, again, we're trying to feed off social media too as well, meaning that as we get tips, we actually follow up on the tip. But if we give all the information out there now, again, with respect to the family too as well, we're giving the answers to some of the questions that my investigators need.
Hostility
Thank
and
you.
even threats made on social media. Can you say anything to calm the community who's very unhappy right
Sure.
now? And there have been threats made, accusations made, things of that nature that you can maybe say justice is being done?
Sure, absolutely. I'm glad you said that too as well. I mean, justice is being served. However, we know the community is angry. This is a very tight-knit community in St. Johns County. And there's great families up there. So they've taken this personal. So again, all we can simply do is we ask them, I'm glad you said that too as well, is that let this case go through the process and go through the system. Let us do our jobs, let the medical examiners do their job, and let the state attorney's office prosecute this case. So I'm glad you brought that up, and please allow us time to do this. And again, let's not accuse people inaccurately. We have the suspect in custody, and we cannot bring Tristyn back. So we don't want to make this case in what it already is. It's bad enough as it is. So thank you.
Is the suspect surveillance play a role?
Yeah, one question at a time, please. Yes, ma'am.
Is the suspect facing any other charges
Uh,
besides second-degree murder?
At this time, again, very early stages. I'm going to keep saying the same thing over again. I hate to say that to you, but again, we're in the very early stages. So at this time, he is charged with second-degree murder. He is in custody, Department of Juvenile Justice. Can we add charges on? Sure, that's a collaborative effort we would do with the Office of the State Attorney. Yes, ma'am. Yes, ma'am.
Can you tell us anything about what they were doing before they ended up in the wooded area? And also, are you still asking for people to come forward from the community?
Sure. If you still have a tip out there that can assist us in this case, we are not going to stop you at all. Matter of fact, our Criminal Investigation Division will follow up on every single tip. Again, we're trying to not release too much information because we still have tips that have not been worked. This is in the first 24, 48 hours of this investigation. These men and women have been out all night long in the Criminal Investigation Division trying to follow these leads up, and we are not done following the leads up yet.
Will he be charged
Sure.
as an adult?
So at this time, that is a decision that was made by the Office of the State Attorney, along with us and the family meeting together. But we believe as of right now, he's being charged with second-degree murder. And again, we'll work with the State Attorney's Office on seeing what they're actually going to do with that charge. Yeah, I'm sorry, one second too. Just to follow up on that question too, we want this process to be finished at the medical examiner's office across the street to add all of those findings together and then present it again to the State Attorney's office and or grand jury. Yes, ma'am, sorry.
The victim, we're told, is a cheerleader. Is the suspect an athlete at People's Academy?
So at this time, we're not going to get into victimology, what she's done in her past. We're trying to verify that, of course, and this is something private. No, I know, I'm trying to cover back up, though, in the original part of that question. We want to make sure we're accurate, too, with her information, too, because I'm going to be honest with you, her information is more important than his. So I really don't care what he did in the school system, whether it be sports or whether it be music. I'm more worried about Tristyn and her family. So as we get into the background of the suspect, that will come out later on in the case. We're still working those leads, though.
You say there were witnesses. Were any witnesses directly at the time of the crime, or just people who saw them beforehand?
I think it's fair enough to say now that we believe we have, of course, our victim accounted for, unfortunately, and we have our suspect accounted for. The witnesses, of course, are just a cumulative getting the case together indirectly or directly prior to. We believe we have everybody accounted for.
But was anyone there at the time of the crime?
We're in the very early stages of this. We have a suspect arrested, and we have, unfortunately, a 13-year-old girl that's no longer with us.
How much did surveillance play a part in getting you guys to an arrest?
Sure, I will tell you this, and I cannot thank our community enough. This is the relationship we have here in St. Johns County with our community. The community helped us solve this case. When I say they went to work, whether it be on social media. I mean, we saw moms and families yesterday walking in the Woodline in clothes like church clothes yesterday. This is how passionate they were about solving this case or helping us solve this case. You all were out there last night. I saw you. You saw families lining the roads. I mean, we had an influx of people trying to donate food and people coming from other parts of the county and the state, law enforcement agencies stepping up trying to help us out. This is a community that's very tight. As you all know, the circumstances are surrounding this, of where everything's kind of at. It's relative to each other. I mean, these kids went to the same school together. This is a very tight-knit community over there, and again, I can't thank our community enough. So between social media and I call it boots on ground, they went to work, and this case was solved because a gentleman saw the information put out there and went to work looking around his immediate area where he lives at. So we can't thank him enough and thank the community enough.
We'll take one more question. Are you able to tell us a little bit more about location? You said Wooded area. Is it closer to Veterans Park? Is it closer to the neighborhood? How far deep into the wooded area did this person have to go to find her?
Sure, and I'm going to leave that to Director Cole if you want to answer any further.
I mean, all I can say is that once we put the mass notification out, people started looking. The gentleman that lived in the subdivision was out on his normal walk and jog, and he was doing a little bit extra digging in a remote area around a pond and located her.
Near the neighborhood or near the, okay.
Yes.
Near his neighborhood?
Yes.
And how did they know each other?
Just classmates, and they all grow up in the same neighborhood.
Were there any threats
Okay,
to
so
her?
we appreciate everybody coming today. I'm going to finish with this, and I hope this is not a personal attack on the media at all. I'm just going to simply tell you this. Yesterday, I asked you nicely that we pay respect to the family as they grieve. And Tristyn's family, of course, listen, I understand your job, and I respect it. And most of you know that, and you've known me a long time. However, this morning, kindergarten, K through 8th, Patriot Oaks Academy, that's 5 years old to about 14-year-old kids, were bombarded by media entering a school this morning. Some of them couldn't even get in there because there was so much media coverage out front of that school. I understand it. I respect it. But I asked you nicely to give them the opportunity to grieve. You think that 5-year-old child walking to school this morning knew what happened yesterday in Durban? Probably not. They do now because they got to go home and ask their parents what happened. Again, this school is grieving. This community is grieving. Tristyn is not coming back. They loved her in school. And we have a person charged for a murder. So I ask you again, I ask you nicely, I asked you yesterday the same thing, that you give respect to the family. In the school up there, you got a principal who's dealing with a large community of K through 8, parents and kids trying to grieve a murder. Not a missing child anymore, by the way. A murder of a 13-year-old girl, Tristyn Bailey, who's not coming back. So I ask you again, please, give this school some respect so they can get the proper grieving in there for these kids and get them home safe and get them through this week and finish out this school year. Thank you for your time today. We appreciate you. As any other information comes up, you'll be notified immediately. As soon as we leave this press conference today, Parade Pass is going to forward you any information that was put out this morning, including the suspect's name and date and age and where he's currently located. Any other updates will come from Parade Pass. Thank you for your day. Have a good day. Be safe. For coming on.
Yep, no sound. Got it. I was muted. My bad. I'm so tired, chat. That Jensen trial took a lot out of me. Sorry. So yes, this trial is going to be aired. So I decided to do this one instead of the Alex Murdaugh trial, just because one, we're behind, and it would have been a lot of restreaming, trying to catch up, and restreaming on the weekend to try to get caught up so that we could, kind of be live on Monday, and with everybody else with that trial. And it would have entailed one of the weekend days basically doing a 16-hour day of streaming. That's a lot. So I was kind of looking around for some other cases that might be going pretty soon, within a week, and found this one. So this is out of St. Johns County in Florida. Aiden Fucci was 14 years old at the time. He is being tried as an adult. Now, there's some interesting factors of this case. So he's being charged with second-degree murder. He's being tried as an adult. He faces life in prison. So because he was a minor, he's not eligible for the death penalty. And we're going to talk about this in a little bit, but because I'm going to give you the details on why this is happening. But he's only getting 6 jurors, not 12. And there's a reason for that. We're going to talk about that. We're going to go through why that happens. So I thought this was also an interesting case for that as well. His defense attorney has been fighting that 6-juror thing. And then we all know about media attention, surrounding these trials and how hard it is to pick jurors during voir dire when there's so much media attention on these trials. And we find out that the public defender's office, did a very unprecedented move that makes it harder to find a jury. We're going to talk about that too. So it's a very interesting case. He's being held at the Duval jail because St. John's doesn't have a juvenile wing, so he is at Duval. We're going to hear some pretrial motions today, kind of give you guys some background. The other big thing about this is his mother was charged with tampering with evidence. So we're going to play some of that clip as well. The mother grabbed his jeans and was scrubbing blood out of his jeans from the night of the murder. Law enforcement found the jeans. There was still DNA blood on the jeans that they were able to recover, and they recovered blood from the drain in the house where mom was frantically trying to clean these jeans off. So mom has now been charged with tampering with evidence. I'm going to play this clip next. We played it right at the very beginning while I was kind of sharing everything out, but we're going to kind of go through this. So they recently released a Snapchat video. They recently released some surveillance video, so we're going to play some of that throughout this. But mom is in trouble now too. So a lot of interesting things. I was really trying to get into the Alex Murdaugh trial. I just can't. It was boring to me. The days we were streaming, I was falling asleep. I know there's some interesting stuff that happened yesterday with that trial, where I guess the son, Paul, was filming the dogs that were in the kennel, and allegedly, like 3 minutes before he and the mom were shot to death. He was filming with his phone. So that was kind of a big break in that trial, a big piece of evidence that got released during that. But it's so much work for me. You guys know how much time and effort I put into this stuff. And it's just, one, I couldn't do it. It was, I'm bored with the case. I don't want to sit here and be bored. And number two, it's too much that I would have to do in the next few days. And it may have even required 2 16-hour days of restreaming. So I'm not doing that. This case sounded interesting because mom's also in trouble. We have teenagers, so this makes it more complicated. There's a lot of controversy around teens that face life in prison or get life in prison sentences. He is currently in solitary confinement. So there's a lot of controversy around that because we know that being in solitary confinement is basically a torturous scenario on adults, and it's even worse on children. So there's controversy surrounding that whole type of scenario. And furthermore, this kid is getting into trouble while he is in jail, getting into fights with inmates, getting into fights with guards. And we have another jail confession. So we're going to deal with some jail snitches. Now, they tried to bar that confession out using a Fifth Amendment argument. But like we saw in Jensen, that doesn't count. It's not law enforcement that he said this to. It's jail people during one of these fights. So we're going to get into all of that too. So yeah, more jailhouse snitches. And then the big thing is that he is only afforded 6 jurors, not 12. And then again, the whole thing with the public defender's office pulls this very unprecedented move, which is going to make it harder to pick jurors. Again, we're going to get into all of this. I don't want to give you all the juice right away because we got a lot of videos to play today. We're going to play some of these pretrial hearings. We're going to play surveillance. I'm going to play the Snapchat video next. It's only like 9-10 seconds. So trying to play this in kind of an order that makes sense of sort of what happened. So we'll kind of pause between the videos. We'll go into some, case details and things like that, and answer some questions to the best that I can. But we're going to learn this case together. This is not like the Jensen case where I know a bunch of shit. We've got all types of footage from a previous trial that we can play. We're going to be diving into this together. At the end, we'll do another jury, like a mock juror thing, which I suspect is going to be very different than how the Jensen mock jury thing was. So let's get into it, chat. Monday morning, jury selection for this trial. And it, from my understanding, it will be aired because the defense team dropped their motion to bar media from airing that. So what I need help with, because I've been downloading videos and trying to read a bunch of background, what I need help with is if somebody can tell me what time this is starting on Monday. That's the one thing I haven't gotten to yet. Plus I'm still editing video from Jensen to try to get all that up. So I need to know what time this is starting and what time that means for my time. So if somebody could find that for me, that would be awesome. Okay, so we just saw the press conference, and prior to the press conference, Aiden gets picked up by law enforcement and put into the back of the squad car, he and his friend, and they're not handcuffed. They're just in the back of the squad. And these two idiots go on Snapchat and post a video. And this is the video that they posted on Snapchat.
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month.
All right, I'm going to play this one more time because it's super short. Pay attention to what Aiden Fucci says towards the end of this video. This is important.
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month.
So, something kind of weird that he said there, where he says, Tristyn, when you walk out the dam, and then he catches himself and stops talking, and the video kind of ends there. So it's not like this was, you know, some 3-minute long Snapchat. Now, it is believed that he was about to say, Tristyn, when you walk out of the damn woods, which is where she was found. So he almost told on himself there. So that's what it's believed that he was about to say there. So pretty interesting. And obviously no remorse. It's a giant joke. Now we're going to get into also some conversation that he had with law enforcement as well. So another one that doesn't know how to keep his mouth shut. And we're going to talk about that. We're going to talk about what that means. What's up, Maya? You should come join us on YouTube, Maya, since nobody's really on Facebook. All right, so we played the press conference. Just played you the quick Snapchat. Now I'm going to play the state's attorney that did a press conference. We're going to play that for you. Let me get this.
To St. Johns County, to the courthouse. I'm R.J. Larissa, the elected state attorney for the 7th Judicial Circuit. Today, the St. Johns County Grand Jury convened and issued an indictment against Aiden Fucci for first-degree murder involving our victim, Tristyn Bailey. Once the grand jury had done the indictment, we did a transfer order, which I believe some of the folks in the media had already gotten a hold of, transferring the case from juvenile court to adult court. The indictment is the triggering document which signals and executes the move into the adult court system. So Aiden Fucci will be tried as an adult in St. Johns County for first-degree murder. Now, Aiden was initially charged with second-degree murder. The indictment is for first-degree premeditated murder. Now, some folks have asked us why, or wanted to know why we would charge premeditated murder, and also why we would choose to seek adult sanctions on Aiden, who is a 14-year-old boy. Well, we're going to talk about both of those together to give you an idea of why the decision was made to charge him as an adult, and why we believe first-degree premeditated murder is the appropriate charge. I think both of those intertwine and will explain why we did what we did. First off, I want to tell you, it brings me no pleasure to be charging a 14-year-old as an adult with first-degree murder. But I can tell you also that the executive team and I reviewed all the facts, all the circumstances, the applicable law, and it was not a difficult decision to make that he should be charged as an adult. It's a sad decision and a sad state of affairs, but it was clear to us after we looked at what happened that it was not only appropriate to charge the defendant as an adult, but it was really the only choice that we could make. Now, you've heard that our victim, Tristyn, was stabbed. And I believe Sheriff Hardwick, who I'd like to say wishes he could be here today. Unfortunately, he couldn't be. But we'll have Director Skip Cole will speak for the Sheriff's Office. But to say that it was horrific could arguably be made as an understatement. The medical examiner completed an autopsy on our victim and identified confidently that there were 114 stab wounds. 114. At least 49 of those stab wounds were to the hands, arms, and the head, and were defensive in nature. The bottom line is that premeditation could be inferred, certainly, from just the sheer number of stab wounds that Tristyn Bailey had to suffer. Every time that arm went back and every time that arm went down, that was premeditation. And it happened, if you times 114 by 2, that's 228. But it's not just the fact that she was stabbed 14 times, or 114 times. It's also information that we were able to glean from witnesses. The defendant made statements to several people that he intended to kill someone. He didn't say who that was, but he indicated to witnesses that he was going to kill someone by taking them in the woods and stabbing them, which are certainly the facts of this case. The defendant had a knife that he carried with him. A knife was found in the pond, very close in proximity to our victim's body. That knife had a tip that was broken off. That tip was located by the medical examiner in the scalp of our victim. The statements that the defendant made to his friends made it clear that he was considering a homicide. And I got to tell you this, it's disturbing and concerning that those statements were not, let's say, adequately or appropriately, or not taken seriously by the folks that heard them. I'm not saying that this could have been avoided, but I'm saying that it was never reported beforehand. Now, as we move forward in this case, and we continue to develop the case, we will continue to develop more evidence. Not only do we have the knife, which was identified by witnesses as they say it's his knife. It's consistent, and the medical examiner says, with the wounds that were found on Tristyn's body. And it's also the description and the hilt and the wounds themselves match up per the medical examiner. Not only that, we also have DNA evidence that we have developed regarding this case. There is the defendant's DNA on the body of the victim. And there is the victim's DNA on the knife blade, on shoes that belonged to the defendant that were found in his bedroom, on a t-shirt that was found in the defendant's bedroom. And there's additional items that we are looking at now that have been sent to the FDLE lab for confirmation of blood and DNA analysis. I just want to say that I hope parents will learn something from this vicious and brutal murder. And that is that you need to know what your kids are doing and what they're saying. Because while we might not be able to stop these brutal and vicious murders from happening, we ought to at least try. And sometimes parents might be reluctant to dig into what their kids are doing. For those of you who have kids, you know that when you start wondering and asking and investigating what they're doing, you have a battle on your hands. But it's a battle worth fighting. So I hope that parents will realize that teenagers are capable of things we have never imagined they could be. And this case is an example of that. What I'd like to do now is invite Director Skip Cole, the Director of Criminal Investigations for the St. Johns County Sheriff's Office, to say a few words.
Thank you. It's difficult to hear all that. Okay, my name's Howard Cole. I'm the Director of the Criminal Investigations Division. I'm here today representing Sheriff Hardwick and all the men and women of the St. Johns County Sheriff's Office. To begin, we fully support the grand jury indictment, which we all know represents only the first step in this very long and difficult process. We remain confident in the strength and thoroughness of our investigation, and we will be fully prepared to present all the facts and evidence to a jury at the appropriate time. We'd also like to thank State Attorney R.J. Larizza and his team for their partnership during this case. From day one, our teams worked side by side, furthering the investigation and preparing this case for grand jury. Even though this case is now being transitioned to the State Attorney's Office, our detectives will continue to investigate all leads and evidence to the fullest. In conclusion, we extend our continued thoughts and prayers to the Bailey family. We want the Bailey family to know that they are not alone, and we will stand with them through this entire process until justice and accountability is served. Thank you.
Now I'd like to invite up Matt Walsh, who was the Assistant Special Agent in charge of the Jacksonville region of Florida Department of Law Enforcement.
Thank you, sir. Thank you. I'm FDLE Jacksonville Assistant Special Agent in charge, Matt Walsh. When a child goes missing or is in danger, time is critical. These are the most urgent cases in law enforcement, and we do everything we can to bring that child home safely. But sometimes, as heart-wrenching as it is, and despite our very best efforts, it isn't always possible. In these cases, we search for answers. Answers for the family and for the community. I'm so appreciative of our FDLE team and our law enforcement partners at St. John Sheriff's Office and here at the State Attorney's Office, Mr. Larizza's office, who dedicate themselves to this case and other cases around this community. Our forensic section had a very big role in this case. They worked tirelessly, around the clock, overnight, to develop the DNA evidence Mr. Larizza has spoken about. Our agents have assisted in investigative support as much as we can, as much as needed by the St. John Sheriff's Office, and we continue that support to you in the Sheriff's Office. Our Missing Endangered Persons Information Clearinghouse, MEPIC, moved quickly to both issue a missing child alert for Tristyn and has been invaluable in providing analytical assistance in this investigation. And FDLE will continue to offer any support we can in this investigation into our community and working through this tragedy. Thank you.
I'd like to also acknowledge the Sheriff's Office, and there were a bunch of folks involved in this investigation, but the case agent was Corporal Hannon, Kurt Hannon, and he's done an excellent job running the investigation and working with our team. And the Sheriff's Office. Cases like this, look, there was video surveillance, there was DNA collected almost immediately. The deputy who responded at the scene to begin with, because remember, this started as a missing persons. Nobody knew what we really had for a while, but if it weren't for that deputy that responded, it could have been a lot longer before we actually were able to figure out exactly what we were dealing with here. And FDLE, folks, you know, testing DNA takes time. I mean, usually it could take months to get the DNA results back. But FDLE stepped up and said, we will process this evidence immediately for you. And I can't thank Matt and his crew enough, the folks at the lab, for doing that. I mean, it truly made a difference in how quickly we could get this investigation over. Also, I'd like to say, and this is really involving the Bailey family. I've met with them twice. They are wonderful, courageous, strong people. And I'll tell you, they're going to need all the courage and strength they can as we go through this process. You know, the juvenile system is not equipped for cases like this. The juvenile system, the maximum time that the defendant could spend in the juvenile system would be 21 till he's 21, and he'll be 15 this year. That is not adequate. That is not adequate or appropriate for what happened here. Additionally, the family has been receiving or has been made aware of comments on social media and threats. I want to tell y'all something. Law enforcement and the state attorney's office will be investigating any and all threats on social media for possible criminal charges. And I want folks to know the family needs your help. They need your support. If you can't give them that, then you should keep your mouth shut. And you shouldn't be using social media as a platform to exploit this terrible and horrific crime that we are now prosecuting. We should all be sad about what happened, and we should all be prepared to stand up and stand with the Bailey family as we work our way through this process. Because I'm telling you folks, the criminal justice process is not friendly to victims and their families. It is a difficult process to go through, and the Bailey family is going to be going through it for years. So please keep that in mind. You folks out there who want to support the Bailey family, please do. Those of you who don't, be careful. Be careful about what you say and do. Now, I'd like to open it up for questions if anybody has some. Yes, sir.
Mr. Larizza, I can tell with just your demeanor, having seen you speak on cases before, have you ever dealt with anything like this? Has your team ever dealt with anything like this?
Well, certainly not the number of stab wounds. And I mean, it's a 14-year-old that is the defendant and a 13-year-old girl who's the victim. I mean, I'd have to say no. I have not before today. Yes, ma'am.
Did the surveillance video show any signs of struggle between the two?
We don't, well, there's a lot of surveillance video. There's surveillance video from when Tristyn and Fucci leave, where they were together and walk down the road. There's several different places. We all know folks have ring videos and other types of videos now. And that there was no signs of any struggle based on those videos. We certainly don't know. We can't see what happened at that point, but we know the result. So there certainly was a struggle. There were defensive wounds on this poor young lady, and she was fighting for her life. And it's just sad that we even have to talk about that. Yes, ma'am.
Any indication at this point in your investigation was whether Mr. Fucci may have been suffering from mental health conditions or was seeing a counselor for those kinds of issues?
No. No.
Do you know?
Yes, ma'am.
The police report that was just released said that Fucci struck Tristyn. Did he admit to stabbing her?
We're not going to talk about any confessions. If there were any, what I can tell you is that there are no statements that I'm aware of made by the defendant where he confesses to the crime. Okay?
You know what led up to them getting together that night? Was he texting her, asking to hang out? Were they having any arguments at all?
These kids, you know, they're teenagers, and they have their groups and they hang out. And so it was started out as just a few kids getting together and hanging out. But it didn't end that way. Yes, sir.
Sir, was this a thrill kill? Was it sexual in nature? I mean, there's so many theories out there. Has your office and have detectives with St. Johns County and FDLE found a motive here?
We're still working and investigating this case, and those details I'm not prepared to discuss at this time. Yes,
on the heels of that, any signs of evidence of sexual assault in the autopsy?
We're not going to discuss details of that at this time either. Yes, ma'am.
What kind of pressure did you feel from the community to charge him as an adult? I know you guys got a lot of calls and emails. How many did you get?
I don't know. And no, I didn't feel any pressure at all. This is my job, to make these decisions along with the executive team. And while we're sad and we certainly take no pleasure in it, this is our duty. And we looked at the facts. We looked at the law. And I got to tell you, and the circumstances of the offense, there was no other alternative. The juvenile system is geared for kids maybe with drug issues or that commit nonviolent crime. When you get kids that get to this level of violence, the time and the accountability is not there, and the programs it's just not there. The adult system is where this case belongs. Yes, ma'am.
Was she tied up or restrained in any way?
We don't have evidence of any of that. The investigation is ongoing, but no, we have no evidence of that. Yes, sir.
What about the other teens? You obviously showed your disdain for their actions for having known about these homicidal statements that he made. Could they face any charges, any punishment, any kind of accountability here?
Well, first off, I don't consider it disdain, disappointment. Disappointment that they didn't talk to somebody. But of course, they're teenagers, and that may be something that you know you could understand. I mean, I was a teenager once. I can still remember parts of that. But what I will say is, no, at this point, there's no evidence that we're aware of that would indicate that any of the kids that were involved, as far as friends who had testimony or evidence, had anything to do with the homicide or in any way have any criminal responsibility. Yes, ma'am.
Is Fucci being held, transferred already to an adult facility? Can you tell us what facility that is, and will he be held at that same facility pending trial?
I can't. That's a decision for the sheriff's office, and I think Sheriff Hardwick, along with the directors, they will make that decision about where he will not stay in Volusia County. I'm fairly certain of that.
Has he already been transferred as we speak?
I don't think so. I think we'll try to get some information to you about a first appearance. I think we will have that for you, maybe even as early as this afternoon, so that if you would like to try and attend or zoom into it, that you could do that. Yes, ma'am.
So will he not be coming to St. Johns County? He might go somewhere else?
At this point, that's still being determined. What we'll do is we'll find out where he's going to be and when, and we'll let you know. We'll notify you. Okay? Yes, sir.
And will he be kept, and this might be for Director Cole, will he be kept by himself because of the notoriety and the horrificness of this case?
Juveniles are kept separately, typically from adults, even in adult county and state facilities, so that they have protocols for that. And if he's held in the St. Johns County Jail, they have their protocols. If he's held in another facility, not run by the sheriff's office, they'll have their protocols, but he will be separated. Yes, ma'am.
Has Fucci showed any remorse?
There's video that I think y'all have access to, you've seen. I think that answers that question. Yes, ma'am.
Do you believe that life in prison without the possibility of parole is appropriate sentence for this?
Well, first off, let me say I think it would be, but that's not the case for the defendant. He could receive a life sentence. He could receive less because of the Graham Miller decisions from the United States Supreme Court, saying that it would be cruel and unusual punishment to have a minor sentenced to life without the possibility of parole. The irony there is, what about what happened to Tristyn? Would you consider that cruel? I certainly would. But the bottom line is that he will be eligible for, if he got a life sentence, that's the first if, he would be eligible for a review at 25 years. And at that point, a judge could decide either to reduce his sentence, leave it the same, or release him. But he will get the benefit of a generous consideration or accommodation simply because he was not 18 years old at the time. Yes, ma'am.
Is there any indication that he was under the influence at the time of the crime?
I don't believe so. Yes, ma'am.
Will there be another first appearance? If so, when?
There will be a first appearance. Not sure when, probably tomorrow, but what I said is we will get you that information. I'll ask Mr. Shorstein, our PIO, to make sure all of you are notified so that if you want to be there or at least zoom in that you can. Okay? Yes, sir.
Mr. LaRussa, if this case were to go to trial, could it be tried here, in your opinion, here in St. Johns County?
Well, I don't know. We'll just have to wait and see. The attempt is always made to try it in the jurisdiction where the crime occurred. And the judge makes the ultimate determination about whether or not to transfer venue. The defense may ask for a change of venue, but typically in my experience, the judge will attempt to do it in the jurisdiction where it occurred first. And if that doesn't work, then pick another jurisdiction. Yes, ma'am.
Yeah. You said that these were kids hanging out. Do we have any indication that they were linked romantically in some way, you know, either before that night or as of that night?
We're continuing the investigation, not prepared to really talk about that today.
Okay.
Yes, ma'am.
Do you know if Tristyn was his target? We heard a rumor that he was trying to lure other girls into the woods that night. Do we know if she was specifically who he intended that night?
We have no information that he had specifically targeted her. The information we have is that he had told friends that he was going to kill someone and that it was imminent within the next 30 days or within the month. And he talked about that to some of his friends several times. But there was never a specific individual identified. And at this point in time, the sad reality is this could have been simply a case of the wrong place at the wrong time.
So did he try and bring other girls out that night?
We have no information in that regard. No, ma'am. Yes, sir.
Does he have a criminal history? We can't see his juvenile records. Can you tell us about his past?
Well, you know, juvenile records are confidential, but no, he didn't.
What about at school? Did he have any misbehaviors at school, getting in fights with kids at school?
I'm not prepared to discuss that at this time. Jessica?
The weapon that was found, was it like a pocket knife that you would carry around on a regular basis?
It was your typical folding buck knife. Buck knife.
Buck knife?
Buck knife, yes ma'am. Buck knife.
Like for hunting?
Well, some people use them for hunting. And they have multiple uses, I would suspect.
Was his family aware that he carried around that knife?
Can't answer that question for you. Don't know. Folks?
Are they cooperating with you, his parents?
We have gotten a lot of witnesses that are cooperating, and that's about as far as I'm prepared to say at this time. Okay? Folks, I appreciate y'all being here. I appreciate your patience. Again, I want to thank FDLE and the Sheriff's Office. And thank you for taking the time to spend a little time with us here today. Thank you.
Sorry again with this microphone. All right. Well, as I was saying, so I'm so tired, guys. I'm so sorry. I decided like late yesterday that I was like, you know what? I'm not streaming this other case. I'm just gonna sleep. So I did. I went to bed and then I woke up at like 12 and I was up until 5, still editing some of the Jensen testimony, trying to get that done and up on the platform. Sorry, I'm not awake. What I was saying was I was unable to download all of the like court documents, the grand jury indictment, a bunch of the motions that were filed. So there's a service that I pay for every month that kind of helps me get some of this. It's cheaper than filing open records requests when I'm just trying to get, you know, a court document for a case file. It's cheaper per month to do that. And we're obviously broke. So the only thing I was able to get right now was this. So what this is kind of a bunch of stuff. So this first page is his first appearance form in court. But now this is up to first-degree murder, right? So I'm kind of just trying to walk you guys through kind of step by step what's happened. So remember, originally it was second degree. So this is his first appearance paperwork. We're going to play his first appearance. We're going to play some of those couple of first appearance Zoom videos. Boss had asked about some mental health stuff. You heard in here the DA was talking about some mental health things. There's some stuff. So this is where we went up to first-degree murder. We have completed our considerations and deliberations on all matters known to merit or require our immediate deliberations. Here's the indictment. So again, I don't have all the full court documents. We'll see if some new donations come in and I can resubscribe to all that stuff. Spring term grand jury in and for St. Johns County, Florida, impaneled and sworn to inquire and true presentment make hereby in the name of and by authority of the state of Florida brings this prosecution and makes the following charge: first-degree murder. Right? So we talked about earlier when we first started the stream, second-degree murder was the original charge. They've upped it. Okay. They're saying he did unlawfully kill a human being, said killing being from a premeditated design to effect the death. Obviously, we can figure out who these redactions are. This is obviously Tristyn Bailey. During the commission of said offense, Aiden Fucci used a weapon contrary to Florida state statute. So we heard that it was a buck knife. We're going to talk about that. Here's the arrest report. So their probable cause on Sunday, May 9th, 2021, at approximately 1,000 hours, St. Johns County Sheriff's Office received a call in reference to a missing 13-year-old female. The initial investigation led deputies to contact the above-named defendant, who provided an initial statement. The defendant's story changed several times, but ultimately made several admissions. The defendant admitted to being with the victim at a mutual friend's house and leaving at approximately 1:10 hours with the victim. The defendant admitted to walking north along North Durban Parkway, which was verified with video surveillance footage obtained from the North Durban Amenity Center, which depicted two subjects resembling the description of the victim and the defendant walking north at 1:14 hours. The defendant admitted to engaging in an argument with the victim in which he forcefully pushed the victim to the ground, striking her head. The defendant further admitted to walking around and got home at approximately 3:30 hours. Video footage obtained from a home on Saddlestone Drive revealed two subjects walking east on Saddlestone Drive at approximately 1:45 hours. One subject was wearing what appeared to be shorts, a light-colored hooded sweatshirt, and white shoes with a black Nike logo. The second subject appeared to be wearing black pants and a black shirt. The video footage depicted only one subject wearing the shorts and the light-colored hooded sweatshirt walking west on Saddlestone Drive at approximately 3:27 hours. The subject walking west was carrying a pair of white shoes with a black Nike logo. The defendant was transported to the sheriff's office and placed into an interview room. While alone in the interview room, which was audio and video recording, The defendant's mother mentioned something about video surveillance depicting the defendant carrying his shoes. The defendant admitted he took his shoes off because his feet hurt. The victim was located deceased on the south end of a retention pond, located just to the east of the cul-de-sac of Saddlestone Drive. The victim appeared to have significant injury to her head and other trauma and was wearing black pants with a black shirt. It should be noted the defendant's residence is located approximately 0.3 miles from the location where the victim was discovered, which is consistent with the timeline established from the video surveillance. A search warrant was executed on the defendant's residence, where several items of evidentiary value were located within the defendant's bedroom, which were consistent with clothing observed in the aforementioned video surveillance. Furthermore, some of these items yielded a presumptive positive test result for the presence of blood. Based on the defendant's statements, the video surveillance, and the items of evidentiary value obtained from the defendant's bedroom, probable cause was established for homicide. Here's the booking, jail booking sheet. Is the charging report. So sometimes, we talk about these types of documents when we're talking about like open records and things like that. Especially like when we're talking about Kenosha stuff, with like arrests of protesters, things like that. We ask for the booking paperwork and arrest records, things like that. So that's what that stuff looks like. All right. All right, so we're going to play this video since we talked about surveillance and stuff at the home.
And developing tonight, new video released in the case of 14-year-old Aiden Fucci. In the moments before and after, police say he stabbed 13-year-old Tristyn Bailey to death in May.
We received a series of videos late this afternoon, including those from inside Fucci's Durbin Crossing home, which show what detectives say is Fucci's mom washing blood off of his jeans.
On your sides, Robert Bradfield is live tonight in the newsroom looking through that video as prosecutors build a first-degree murder case against the St. Johns County teenager. Robert.
Well, good evening. That video inside Fucci's home is about 16 minutes long, but we're going to show you just the first part, which shows his mother, Crystal Smith, walking into an upstairs bathroom. And that is where the state's attorney says Smith is seen cleaning her son's bloody jeans. When officers went into the home, they found a pair of wet jeans in Fucci's bedroom. And as we reported earlier this summer, the jeans and a drain in a bathroom tested positive for blood. Smith was arrested in June. She is charged with evidence tampering. Now, other video released today shows who detectives believe are Fucci and Bailey walking in their neighborhood on the morning of May 9th, the last time Bailey was seen alive. Later that morning, a person who is believed to be Fucci is also seen returning to his home, wearing a sweatshirt and holding white shoes, matching the same description that was also caught on another home surveillance camera earlier that night. Now, Fucci is charged with first-degree murder and Bailey stabbing death. He's pled not guilty. Coming up tonight at 11, we are talking with...
All right, so that was that video. We'll play this surveillance video for you. So there is a second part of this surveillance video. Sometime after the two of them are seen walking past, there's a second part. I didn't grab that, so I'm just telling you about it. There's a second part where it's alleged to be Aiden running back in the opposite direction by himself, which is consistent from where Tristyn was found. So here's the surveillance video. So right here, this is alleged to be the two of them. So this is supposed to be consistent with the direction in which she was found, towards this retention pond right by the wood line. And then, like I said, there's another piece of the surveillance video where one of those individuals matching the description that we just saw here comes running back pretty fast in, the opposite direction of what we just watched there. Now, when he was with police, so we kind of read in the police report there about some statements. So originally, Aiden told cops an argument erupted between the pair as they walked back from a friend's house in the early hours of the morning, showing deputies the path they took. So when we saw Aiden in the squad car, the sheriff's department made him, drove him around the neighborhood, made him tell where, the path that he walked through the neighborhood. Showing deputies the path they took, Fucci claimed to police that when the two passed Leith Hall Drive, Bailey grabbed his penis, which made him pissed, and an argument ensued. Told authorities he then pushed her hard to the ground and she hit her head. And there was another statement that he made. I'm trying to find that now. Because he told them a different statement originally. I'm trying to find that article because I closed out of it like an idiot. We heard the DA talk about how Aiden had planned to stab somebody. Yeah, there's more peen talk. I figured it was consistent with what we've just been doing. State's Attorney's Office released new documents regarding the investigation into the murder of 13-year-old Tristyn Bailey. St. Johns County teen was found dead on Mother's Day after being reported missing by family that morning. It was Tristyn's mother who first contacted the sheriff's office to report her daughter's disappearance sometime after midnight, May 9th, and provided deputies with a list of Tristyn's friends and their possible locations. What's up, Christine? So there's supposed to be, they have a witness list. The state has a witness list of 200 people. 200 people on their witness list. One of their friends, a classmate of Tristyn and Fucci, told St. John's investigators that the pair had been hanging out at his house and left together around 1 a.m. That's when it's believed that Tristyn had been brutally attacked around that time. Fucci initially told investigators that he left that mutual friend's house with Tristyn and they walked together until she turned onto her street. So that was an inconsistent statement that he made. They said they walked together and then she turned onto a different street to head towards her house. He continued on, I believe, Durbin. And then he changed that story to they both continued onto Durbin Street. And then this is where this argument or dispute kind of ensued because she allegedly grabbed him in the crotch. When asked why it took so long to get home, Fucci told detectives he walked around alone for a while, telling deputies he kept walking until he got home between 3 a.m. and 3:30 a.m. Fucci agreed to show deputies the path they took and got into their patrol car. So that's where we see the Snapchat video, this video right here. Play it again. Some of you are new.
We're having fun in a fucking cop car.
Yep. Tristyn.
What's up, guys?
Yep.
Tristyn, if you fucking walk out the damn...
When you see this in a month.
So that's a clip from the Snapchat video. Now, there is another disturbing thing that he did on Snapchat. There's a photograph. He took a picture, and the caption on the picture that he put on the Snapchat was kind of him laughing, and it said, "Has anyone seen Tristyn lately?" So kind of demented. It's pretty sick. When the two passed Leith Hall Drive, Fucci told investigators that Tristyn grabbed his penis, which made him pissed. An argument ensued. That's when he told authorities that he pushed her to the ground where she hit her head and left her there, according to the report. While in the patrol car, the report states Fucci at one point began crying and punched the back of the seat, saying, "I'm going to get arrested for bullshit." During a search for Tristyn, documents show a neighbor found her clothed body in the woods near a retention pond while out for a run near the cul-de-sac of Saddlestone Drive, and alerted authorities. That location was 0.3 miles from Fucci's home. Tristyn, according to deputies, was found with significant injuries to her head and other trauma. Deputies obtained a search warrant to gather evidence at Fucci's home, where they found several items that tested positive for Tristyn's blood. So that's pretty damning evidence. Pretty damning evidence. Blood in the actual home. Is Bobby Boy the prosecutor? No. Hey, speaking of which, that's another thing. If you guys want to help me figure out contact information for Bobby Boy, because we need to send him an email. Yeah, so we're still trying to get the phone turned back on if you guys want to help. In the hours following her disappearance, investigators interviewed dozens of people, from Tristyn's neighbors to her friends, their parents, and acquaintances. In one interview, a female classmate told detectives Fucci asked her if she could sneak out of her house the same night Tristyn disappeared, but that her mother had said no. The girl told investigators that when she informed Fucci she could not sneak out, he called her several derogatory names. She later told detectives, "It could have been me." Early in the investigation, deputies conducted an interview with Fucci's cousin, who reported that he was usually at her house multiple times a week. The female minor told investigators the last time she had seen her cousin was Thursday, May 1st, but she had spoken to Fucci after he sent her a photo of himself from the backseat of a patrol car. In the Snapchat photo, which was quickly shared among many of he and Tristyn's classmates, Fucci can be seen in the backseat of a police cruiser holding up a peace sign with the caption, "Hey guys, has anybody seen Tristyn lately?" When asked if she had ever witnessed any odd behavior from Fucci, detectives say his young cousin stated Fucci once told her, "We might go to jail sometime in our life," and that for him, it may be for something big. Two friends told investigators that Fucci told them on multiple occasions that he wanted to kill someone by stabbing them or slitting their throat, according to the documents. One of those friends also told investigators that Fucci said he was going to kill someone and they should expect it to happen within the month. So we heard the DA say that. The friend also said that Fucci said if he were to kill someone, it was going to be planned. He would find a random person walking at night, drag them into the woods, and stab them. Pretty damning evidence. Those same two friends said that the Buck brand folding knife that investigators recovered was identical to the one that Fucci would carry. A Buck brand knife with a wood and brass handle was found in the pond where Tristyn's body was found. State's Attorney's Office said the tip of the knife was bent and broken. It was later confirmed to be found on Tristyn's body during an autopsy. Now, here we go with some of the mental health stuff, and you're going to see some of this stuff in the videos that we're going to play for you today. During the investigation, detectives found disturbing drawings that Fucci had created. Fucci had satanic and violent drawings in a notebook of his and on his desk. A drawing of a nude female with her arms cut off, blood coming from wounds, and red X's over her breasts and genitals laying on Fucci's desk, a detective observed. In Fucci's notebook, the drawings had satanic elements, including a pentagram. Very interesting. So let's play. We're going to play his first court appearance, and then I'm going to play you another video that we're going to learn a little bit about some of this demons and satanic stuff. This is the first court appearance.
May 28, 2021. I'm Judge Maltz. This is the first appearance in the state of Florida versus Aiden Fucci, which is case number 21-825 CF. Are you Aiden Fucci?
Yes, sir.
Okay, very well. State is here represented by Mr. Lewis. Mr. Fucci is here represented by Ms. Peoples. Good morning, everybody.
Morning, Judge.
All right, Mr. Fucci, if you'll raise your right hand for me, please. Do you solemnly swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. All right, Mr. Fucci, let me tell you what first appearance is. The purpose of a first appearance is to advise you of what the charges are against you, to let you know if there is probable cause to detain you on these charges, to address the issue of your bond if appropriate, and to advise you of some rights that you have. So I am going to start with advising you of some very valuable rights that you have under both the United States and Florida constitutions. First off, you have the right to be represented by an attorney at this and every stage of the proceedings against you. And if you could not afford to hire one, one will be appointed for you at no cost. I know that the Public Defender's Office is currently appointed to represent you. Judge Anthony had a hearing last week and determined that the Public Defender's Office could represent you in this matter. So I am going to reaffirm that appointment of the Public Defender's Office at this time. You also have the right to remain silent. That is also referred to as a right against self-incrimination. What that means is that no one can force you to talk about your case while your case is pending. Keep in mind that everything this morning is being recorded. There's also an assistant state attorney on the line. So if you say anything that's incriminating this morning, it may very well be used against you at a later time. Do you understand these rights as I just explained those to you?
Yes, sir.
All right. So let me tell you what you are charged with. You have been indicted by the St. Johns County Grand Jury on the charge of first-degree premeditated murder. That is a capital felony that is normally punishable by up to death or life imprisonment. In your case, because you are not yet 18 years old, death is not a possible sentence pursuant to the Florida and United States Supreme Courts, but this charge does carry a maximum penalty of life imprisonment. Do you understand the charge against you?
Yes, sir.
All right, there is probable cause to detain you on this charge pursuant to the indictment issued by the St. Johns County Grand Jury yesterday, as well as the arrest affidavit that I have previously reviewed. The indictment in capias that followed set your bond at none. Is the state still asking that he be held without bond? Mr. Lewis?
That is correct, Judge. The state's request is no bond.
All right, Ms. Peoples, do you want to be heard on that issue?
We'll address that issue at a later date, Your Honor, with appropriate motions and witnesses.
Okay, thank you. Having reviewed the appropriate paperwork, I will preliminarily make a determination that proof is evident, presumption is great, so you will be held without bond. Mr. Fucci, do you have any questions about these proceedings today?
No, sir.
All right, the next step in these proceedings will be an arraignment unless your lawyer or lawyers formally waive your arraignment in writing. and that will take place in the next week or two. Anything further from the state?
Nothing further from the state, Judge.
Anything further from the defense, Ms. Peoples?
No, Your Honor.
All right, that will conclude your first appearance, Mr. Fucci. Everybody have a good day.
All right, so that was the first appearance. Now I'm going to play you another one, and this is interesting. So I want you guys to watch this. Let me know what you guys think. He's got a lot of drawings at the house, satanic images, killing images. Is he playing games, or is this real? Could there be some serious mental health issues? Another one, possibly with some paranoid delusions. This is similar to what we saw in the Travis Reinking trial.
What the hell y'all got going on? What the hell y'all got going on? Sure. What's going on? I don't want you demons. I don't want you demons take my soul. You demons want to take my soul away. I don't let you demons steal my soul. I don't know what's going on. I've seen him before. What's going on? What you got going on? Why am I here? I just want to talk to my mom and dad. What's going on? What's going on? What's going on? What? I used to. I'm not that, but why am I all in these chains?
All right, so we're going to drop that out there. You kind of get the idea. So, boss says he didn't act like this during the last hearing. I'm not buying it. Here's the thing with these paranoid delusions is you don't act like that constantly. It comes and goes, and it depends on a variety of situations that happen. There's things that could trigger that. So it's interesting, very interesting. Now, a little bit more background detail, some timelines, some dates, all of that type of stuff. So we have, in regards to evidence and discovery and all of that, so the list, which is called discovery, includes names of 154 potential witnesses. Like I said, that's been kind of upgraded to 200 potential witnesses. Witnesses include law enforcement from the St. Johns County Sheriff's Office and Florida Department of Law Enforcement analysts, people who were present during statements made by Fucci, like his mother, Crystal Smith, who is now facing a charge of evidence tampering in connection to Tristyn's killing. She was set to appear in court on July 26th. I grabbed that video, but it's really, really boring. It's like nothing. So I'm not going to play that today. St. Johns County Medical Examiner. The exhibits listed in the state's discovery list include audio recordings with Fucci, Smith, as well as Tristyn's parents, downloaded contents of cell phones for Smith and Fucci's father, Jason Fucci, shoes and T-shirt collected from Fucci, results from phone subpoenas for Fucci, Jason Fucci, as well as a person identified as TB. So I would assume that's Tristyn Bailey. Aiden Fucci's school records, which are listed as 42 PDF files, search warrants for the phones of Fucci and his parents, Fucci's Snapchat, as well as the Instagram and Snapchat accounts for Tristyn Bailey, 5 video files and 2 JPEG files from Snapchat, surveillance videos from Fucci's residence, neighborhood videos from 5 different locations. Now, we talked about Tristyn was found Mother's Day, May 9th. Okay. On May 10th, Fucci, Aiden Fucci was charged with second-degree murder, right? We talked about that. Okay. On May 11th, investigators revealed that Tristyn had been stabbed to death. So that's what the press conference was that we watched. Okay. There was a memorial service for Tristyn on May 18th. On May 21st, Fucci's original attorney was allowed to withdraw from the case, and now Fucci is being represented by the Public Defender's Office. On May 27th, the state's attorney's office made the decision to charge Fucci as an adult with first-degree premeditated murder. So we saw that document where, I specified that now it's been upgraded. So that was done 11 days later. May 27th, state's attorney's office, 17 days later, charged him with first-degree attempted murder. Because Aiden is a juvenile, a death sentence is not an option, but the charge carries a maximum penalty of life in prison. June 3rd, he pled not guilty. June 5th, Crystal Smith turned herself into the St. Johns County Sheriff's Office on a charge of evidence tampering. She was going to court June 26th. So let's get into some trial coverage. What's up, Nanny? Yeah, this kid's kind of fucked up for sure. I figured, guys, this one was going to be a little bit harder to watch, right? It's 'cause it's tough, right? Because it's children. But why can't I fucking play this video? What the fuck? It won't let me play this video. Hang on. I don't know what the fuck the problem is. Let me try it a different way. But yeah, I figured, it's going to be a little bit harder to watch because they're kids. But this is always interesting because, like I said in the beginning of the stream, there's a lot of stuff when it comes to children that are sentenced to life in prison, right? And when we hear about these types of crimes, and they're heinous, and a lot of times with kids like this, it's usually a very heinous type of killing. And the problem where everything starts becoming so controversial is the fact that they are kids, right? And their brains are not fully developed. And it's said that there could be like a higher percentage of rehabilitation for them as opposed to like an adult that does this, right? And the effects of them, because like I said earlier, he's sitting in all right, cool, Maya. He's sitting in solitary confinement, right? And the effects that solitary confinement has on adults, and then we're doing that to a child. So that's crazy. A lot of controversy surrounding that as well. Some people believe that he should be in a hospital, housed in a hospital, not jail. In prison, is he in general population? So no, because again, he's a juvenile. So if he's found guilty of this, right, which again, we go back to that judging right away. Sounds pretty probable that he will probably be found guilty of this. There's a lot of evidence stacking up against this kid right now. But no, he'll be in solitary confinement again because he's a juvenile. That's if they have a juvenile unit, and not all prisons have juvenile units. So if there's one in Florida that does, then they may send him there until he's an adult and then transfer him somewhere else. But otherwise, we've kind of seen in the past where these children that are going to adult prisons, they're housed in these separate private units, and it's usually a solitary confinement style unit because he cannot be around adults. It's like big, massive federal laws over that type of stuff. He cannot be around adults. So that's another thing. There's so much controversy around that as well. I mean, it's really fucked up. There's a lot of stuff surrounding this case. So, all right, let me see if I can play this video this way. For some reason, I wasn't able to pull it up on the stream the right way. This is one of his court hearings. So we're going to play these pretrial hearings. They try to exclude evidence. We're going to talk about this really unprecedented move by the public defender's office. We're going to play, the solitary confinement thing. His attorney starts arguing the torturous history of that. We're going to play a bunch of these. So you'll get to listen to some of these arguments that are being had. kind of from watching this, you know, public defender is kind of weak. What the fuck? All right, so that was that. Some of these guys, you're going to have to turn your volumes up a little bit because they really suck at using microphones in this courtroom. So here's one to exclude some evidence. And let's play this one first. Let's do this one. Hang on.
Sometimes known as a first appearance. The purpose of your detention hearing is to determine whether there is probable cause for me to believe that an act of delinquency occurred and that you are the person who committed it. If I find that there is probable cause, we will then discuss the terms which the law allows you to be either released or detained. There's some things that you need to be aware of. First off, you have the right to remain silent. Anything you do say in this proceeding can be used against you. This proceeding is being recorded, and the assistant state attorney is here, and she will be taking careful note of anything you say. Secondly, you have the right to be represented by an attorney. And if you or your family can't afford an attorney, I will appoint one to represent you. Now, let me just ask your parents briefly, do you have private counsel here today to represent him?
Yes, we, well, his attorney should be there, Andy. Anwar Snober.
What's his name?
Anwar Snober. Andy Snober.
Okay, I do not see
Mike, call him.
him on the Zoom call.
1 second.
Well, we just had someone enter the Zoom call. Let me see if this is him.
Okay.
What did you say the name was?
Andy Snober. Huh? Anwar Snober. It should.
That is not who I just admitted to.
Can we call him?
If you can get him reasonably quickly, otherwise I'll appoint the public defender for this
Mike,
matter.
he's gonna have to answer.
He's having a computer issue glitch.
He's having a computer issue glitch and he's trying to log on.
Well, while he is attempting to log on, as I said, to Aiden,
Mike, he's gonna.
he has the right to counsel at every stage of the proceedings. If you can't afford counsel, I can appoint counsel. I see that Mr. Snober is now joining the call. Mr. Snober, would you please turn your camera on? Thank you, sir.
Good morning, Your Honor.
Good morning. We've already begun your client's detention hearing. I have informed him of his right to remain silent and his right to counsel. His parents advise that you are representing him. Is that correct?
Yes, sir.
All right, you see him there on your. I have reviewed the arrest report. Mr. Snober, do you have any comments on probable cause?
No, sir.
Okay. I do find that there is probable cause to believe that the offense occurred. And at this time, I'm going to order that Mr. Fucci be detained by the Department of Juvenile Justice in secure detention for 21 days or until further order of the court. The 21-day period will end on May 31st, 2020. Ms. Paula, I take it the state will have made its filing decision by that time.
Your Honor, if
There we go.
sorry, if I may, Jennifer Dutton for the State Attorney's Office. Yes, Your Honor, that decision will be made in that time frame.
Oh, okay. I'm sorry, Ms. Dunton.
That's okay. That's okay.
Handling this. All right. Do you have any other comment, Ms. Dunton?
No, not at this time, Your Honor.
All right, Mr. Snober?
No, sir, not at this time.
All right.
All right, so I'm gonna remove that video. It was just a little clip you got to see there. It showed the retention pond that she was found at. Kind of disturbing. But here's a part. So they're trying to exclude a bunch of evidence. Obviously, his statements. They're trying to exclude the drawings. Now, they were able to exclude. The judge ruled that the drawings that they found in the notebook are not relevant to the case. And they found several knives at the house. And the judge ruled that none of those knives are relevant to the case either. So those two things are gone. But let's play this clip, this video here. So this is the hearing to exclude evidence. So if you guys are just tuning in, this is the next trial that we're going to cover. It is set to begin Monday. I do need help trying to figure out the time that this is starting. I've not been able to find a single article yet on what time this starts, but jury selection will start Monday. It is expected to be aired. Defense filed a motion to bar the media from being in there, and several news outlets were in court prepared to fight that motion, and the defense ended up dropping the motion. So it is expected to be aired. So that's why we're playing this stuff today, give you guys some background details about this case. This is kind of not kind of, I mean, it is a very disturbing case. Should be pretty interesting. I kind of rather cover this anyway, as opposed to the Alex Murdaugh trial. It's just too much to catch up on in that trial. I'm bored with it. There's a lot of legal issues that surround these child trials. One of the biggest things is, and we're going to talk about this, we are going to get into this, chat, is that he is only afforded 6 jurors, not 12. We're going to get into that. And then there's this crazy, unprecedented move that the public defender's office did when it comes to knowledge of the case. We're going to get into that because it is fucking crazy. I've never even heard of a public defender's office or an attorney, a state's attorney's office. I've never heard them do this. We're going to get into it. I'm going to tell you what that is. It's the most bizarre thing I've ever heard. They do this thing that we're going to talk about. I don't want to spoil it. And then they argue that people know too much about the case. Kind of surprised that sanctions weren't filed, but so what we're watching here, this is a hearing to exclude evidence. Make sure you guys share the stream out. I don't really have a lot of people watching right now. On YouTube, hit that thumb. There's nobody watching on Facebook. A lot of it, guys, I know some of you said you didn't get notified. A lot of it is because we're still uploading Jensen videos. And some of those videos we're reaching our kind of maximum for the day. I'm so behind on other videos that I want to get uploaded to the channel. Once this trial starts, we'll be covering the trial. Expect for on the weekends, obviously with Jensen, you know, we were able to do a lot of background stuff and kind of some continuous coverage. Expect on the weekends to have some different content uploaded to the YouTube channel that have nothing to do with trials. There's some big stuff happening in Kenosha from the Kenosha riots. So I told you, I had mentioned yesterday, somebody had asked about what my thoughts were on certain things. And I said, there's civil cases. So there is a wrongful death lawsuit in Kenosha that was filed. It was filed in 2021. So this is the death of Anthony Huber. And we're kind of getting back into that. So we'll do a brief discussion about that after we're done with some background stuff here with Aiden Fucci. I'll give you just a brief thing about what's going on with the wrongful death of Anthony Huber from the Kenosha 2020 riots. So expect to have some live streams coming up regarding Kenosha again. For those of you that are new to the platform, since we are going to be talking about Kenosha, expect the chat to be full of bullshit. We're already prepared for the death threats that are about to come again. I don't know if I will be called as a witness for this. I'm not sure on this lawsuit. However, I have already been contacted. So prepare for the bullshit, chat, because it will come. We will get harassed. There will be death threats. There will be bullshit. We're already preparing for this. And the misinformation and disinformation is already going out again. So for my mods, when we're doing Kenosha streams, we'll definitely need you guys here. We will probably need one of you. Day Drinker, if you're still here, we'll probably need you over on Facebook dealing with some bullshit. So you and I'll attend to that. Boss, you're just going to have to start whacking people. And we will be adding people to the block list. That's right, boss. We got like 1,500 people being blocked on YouTube already. We're going to expect some more. So, I don't know if I'll be called as a witness officially. I have no idea. I have been contacted because here's the reason why. Is because we have so much Kenosha video up on the channel. We have so many documents. There's so much shit. Is that in regards to Rittenhouse? Yes. So it's a wrongful death lawsuit that's filed against Kyle Rittenhouse. There is one from Gage Grosskreutz as well for the shooting of him with his arm. And there is another one for Joseph Rosenbaum. So it's called the estate of Joseph Rosenbaum and then the estate of Anthony Huber. Just the legal verbiage that's used in those. So we'll be doing a lot of coverage on this. So like I said, I have been contacted because I told you guys there's certain things I can say and there's certain things I can't talk about because there are lawsuits. This is what I was referring to. So we can kind of talk about that a little bit now. So this, again, was filed in 2021. It came up again yesterday in national news. And it's been kind of being talked about on social media again. So it's going to get hairy everywhere. So for those of you that want truth about Kenosha, okay, not to sound braggadocious or anything, but we're kind of, Never Stop Media is kind of the foremost expert at this point. We have by far the most compiled video footage and by far the most documents and audio and all of that type of stuff. Nobody has everything that we have or most of what we have. No other channel has it. If you guys remember, this is an ongoing investigation for me. This has been over 2 years. So we still have 25 different law enforcement agencies to file open records on. We know there were 51 agencies that were out there. We have filed on 26 of them.
All rise.
All right, here we go with this.
St. Johns County Circuit Court is on session. The Honorable Judge Smith presiding.
Good afternoon, everyone. Please be seated.
All right, let's go ahead and go on the record. We're here on case 21, CF 825. Who out here on behalf of the state of Florida?
Is this the state attorney, Jennifer Dutton?
Mark Johnson. And on behalf of the defense?
All
All right, Mr. Fucci is also present.
That's correct.
All right, we are here for some motions that have been filed by both sides. The first motion that the court had received was the state's demand for a constitutional right. Excuse me, that's the defense's. Was the state's motion to panel a 6-person jury. I then also received a response and a motion from the defense requesting a 12-person jury. So let's take that up first, and then I will proceed with the other defense motions that have been filed recently. Ms. Dutton, will you argue for the state?
Yes, Your Honor.
All right, I'll hear from you at this time.
Your Honor, we filed this motion based on, as Your Honor sees in the motion filed, beginning with the case Walling v. State that was decided back in 2013. That was a juvenile that was charged with first-degree murder, and he was charged, or excuse me, went to trial with a 6-person jury, and that issue was litigated on appeal. The court in the first DCA in that case held that even when a statute defines an offense as a capital crime, the 913.10 does not require a 12-person jury if federal constitutional requirements rule out the death penalty as a possible punishment. So because death is not a legal option here at all, sort of beginning in that case and then moving on through other cases, and as recent as 2020 in the 5th DCA, that was a case of a juvenile charged with capital sexual battery, but the same legal reasoning was applied there. That is a case where legally the defendant cannot receive the death penalty. Well, an adult can't either, but again, because juveniles cannot receive a death penalty for that, just because it's titled or classified as capital in the Florida statutes for other purposes, it does not mean they're entitled to a 12-person jury. So based on that long-standing case law, we filed this motion and would ask that the court do that. I would just also comment on one of the cases in which Ms. People cites in her response, Johnson v. State, which cites Poole. That case, actually, if you read that case in its entirety, they state that there is no constitutional right to a 12-person jury. That is determined by each state in its statutes and procedure rules. And that case in and of itself distinguishes itself from all of the ones related to juveniles that have been held that 6-person juries are appropriate. This was a different situation, Judge, in that case. There's a lot of cases where, like, let's say adults have been charged with first-degree murder and the state either neglected to file a notice to seek death or on purpose did not seek death, and so maybe it was attempted in those cases that the state was like, well, we can do 6 in this scenario. They've drawn a distinction between that because death is still a possible sentence for an adult for first-degree murder. So there's a distinction between that and juveniles charged with crimes because they cannot be sentenced to death, and also adults charged with capital sexual battery because legally it is not an option, so therefore 6 is appropriate. So that's our position on that, excuse me.
All right, thank you.
Good morning, good afternoon, Your Honor. May I remain seated beside my client?
Sure.
Thank you. So, Your Honor, I would agree in terms of the statutory
legislative body has decided statutorily who gets 6 and who is entitled to a 12-person jury in the state of Florida. And in the state of Florida, that rule 3.270 is that it is a 12-person jury for a capital case. And then we turn to statute 913, and then again, it is 12 on a capital case. So the question is this a capital case? Now, the state did point out in the cases that it provided to Gostino and Walling, and they're distinguished by Johnson. See, in the Gostino case, that was not a homicide case, and it wasn't a capital first-degree murder homicide case, whereas that's what we have today with Mr. Fucci. So capital felony is described by Florida Statute 775.081, defines a capital felony. It's not ambiguous, it's unambiguous, and it's pretty clear that this particular case that Mr. Fucci is now pending charges on, as charged as first-degree murder, is a capital offense. This is specifically the type of case that a 12-person jury is designed for in the state of Florida and that the statute had in mind. So I understand the state's position is that it's determinative on whether or not death is being sought, and that's not the case. It's what does the statute say. The statute is very clear that on a capital offense, which this has been classified as by the state of Florida, the rules are clear, the statutes are clear that he should receive a 12-person jury. So the case that I provided was Johnson. Johnson is similar in the charge. I know the state would like to look at the defendant, but we're looking at the statute and we're looking at the charge. So his age is not the determining factor, it's the actual statute and the charge. So looking at Johnson, it cites back to an older case of State v. Griffith. Again, that individual was indicted for first-degree murder and he's entitled to a 12-person jury. And here's the catch, it's unless it's jointly waived by state and defense. That was the position of State v. Griffith, 561 2nd 528, and that's the Florida Supreme Court in 1990. And then we move further down to the case of State v. Wong, and that's at 3rd DC in 2019. And both of these, and Poole, which is distinguishing Hogan, is making it clear it is not, it's not a question of whether or not the death penalty is being sought, it's whether or not it's a first-degree murder, and if so, a capital first-degree murder, I should say, then that individual is entitled to the 12-person jury unless waived by the defense. And that's part of why we have that case in Johnson, because that defense had objected continuously to a 6-person panel. And here, that's what we're having now. We have Defendant Fucci through counsel. We've formally asked for a demand of 12, which I haven't had to do in the past on any first-degree homicide case. But we're asking for 12. He's not waiving. We're objecting to a 6-person panel, and the statute controls on a case like this. So in light of that, we're asking the court to follow what the legislature has made clear as to what is a capital offense. It's not dependent on whether the state is seeking a 12 or 6-person jury. It is on the defendant to waive or not object to a 6-person panel, and we are in this particular, this specific case.
All right, let me I know the audio sucks, guys. There's nothing I can do about that. She doesn't have her mic turned on. When the state talks, they're louder because they're not dumb. She's kind of soft-spoken to begin with anyway. But let me tell you what she's talking about. So normally we're all used, and this is another reason I wanted to cover this case, because it's different. It's different than what we're used to. So we're used to 12 people on a jury, right? And then there's 4 alternates, 6 alternates, 8 alternates, right? Now in a capital murder case, by law, they have to have 12 jurors, okay? By law. Because of his age, okay? And I know that I'm being louder than the. Oh, you turned it. You guys are turning your stuff up, and then I paused the thing, and then I jumped on. Sorry, guys. Sorry. My indication is I'll make their video smaller, and then you see me turn your volumes back down. Sorry, I'm blowing everybody's ears out. Okay, so the state filed a motion for a 6-person jury. Okay, so I think it's kind of a shitty move by them. Probably still should have been 12. I think it's a shitty thing. But I'm expecting, though, that we're going to hear maybe some argument, especially at the end of this, on whether or not he's going to be sent to like an adult prison or some type of hospital, some type of different facility due to his age. Remember, he's still a child, right? He was 14 at the time of this, but he is being tried as an adult. So they filed a motion to impanel a 6-member jury for the trial. In the motion, the state says that while Fucci is charged with first-degree murder in the stabbing death of Tristyn Bailey, it's not a capital case because of his age at the time that he allegedly unalived this young girl, right? So as a media outlet, guys, I got to be careful with some verbiage. So I got to use the word allegedly. Even in the Rittenhouse thing, I still have to use the word allegedly shot people, even though we all watched it live happen. But he was found not guilty. So, it is what it is. Anyway, so Aiden is not eligible for the death penalty, only life in prison. So that's what, I had talked about. The state goes on to say that given the reality, state law allows for a 6-member jury, not a 12-member jury. A criminal defense attorney not affiliated with the case says state law allows for this jury size reduction in very specific cases. So naturally, the defense would prefer a 12-person jury because that is going to be a more diverse jury panel. It's going to be more people to convince. There's going to be 12 people that they have to convince versus just 6. So that's why the state will naturally prefer a 6-person jury. So that's what this hearing is about. It's about that. It's about some other evidence and things like that they want excluded. So yes, it's about his age because he was a minor. It's what makes it technically under the statutes with Florida law, it's not considered a capital case, capital murder case because of his age. If he was an adult, it would be a capital murder case and it would have to be 12 jurors. So some weird little legal technicalities with this case. So I know I'm sure a lot of you guys don't like this kid already, but what do you think about that? Has anybody heard of this before? This is the first time I'm hearing of this. So it's kind of weird to me. I'm not sure if I like that. I don't know if I agree with that, but Florida law says it can happen. What do you guys think?
This morning I've read the case law, familiarized myself with the rules and the statutes, and the court is going to grant the state's motion to impanel a 6-person jury pursuant to Wally v. State 105 Southern 3rd 660, the first DCA case, and State versus D'Agostino 303 Southern 3rd 606, a 5th DCA case, both of which support the idea, concept that an individual who is charged with a crime, unless the death penalty is an option, which in this case it is not, as it is clear from the Constitution, prior rulings that the death penalty is not an option for any juvenile in the entire country. This is not something that was a possibility that could have been waived by the state attorney's office. So therefore, the defendant is not entitled to a 12-person jury. So the state's motion is granted, the defense motion is denied. All right, let's move to the next motion, which is the motion of limine regarding autopsy or other defined photographs.
Your Honor, I believe the state wanted to table this one and that they were going to let us know specifically what items on which phone.
Well, my position is as written, obviously, it's just a motion stating that I can't bring in any evidence from any cell phone seized with no legal basis in here. It was very broad, and I think by practice, Ms. Peoples knows I don't do that. I don't introduce entire cell phone dumps that are not relevant and not probative. So what I would like to do is we're still prepping that and meeting with digital experts, our law enforcement officers. So I will absolutely tell her when entire phones are ruled out, and I'll give her an idea of evidence if we intend to use it from cell phones.
We'll just have to table it, take it up.
Yeah.
Right. I'm just addressing the issue of there's Florida Rule 3.190 is what we're moving forward on, and we provided case laws for the basis of it. But if we could table it, if the state's in agreement to narrow down, it's the volume involved with the material on the phones is great.
Right. The problem with the motion is she's, I guess, asking the court to do a probative prejudicial test and not outlining any evidence that she's objected to. So
the specific objection, Your Honor, is to the probative value on the items on these phones that bear no weight to the charged offense before the court. So
how do I know what items those are, though?
Right. So whether it's because of the volume, Your Honor, yes, defense team has gone to the phones, but we're looking at a large amount of information that has no value on these charges, and that's why we filed the motion.
I understand, but I think what the state is suggesting is that they will let us know specifically what they intend to utilize from the phone. And then at that time, if you wish to continue with your objection to any specific items, otherwise everything else they're not going to introduce is kind of moot. So anything that they plan to introduce from either the cell or any of the cell phones, they must let you know in advance, obviously. And then at that time, if you have an individual objection to anything specific, then we'll take that up prior to trial or jury selection if we need to. But state needs to obviously give Ms. Peoples sufficient notice so that they have an idea of what specifically you intend to utilize from the cell phone dumps, so that they can then, if they do wish to object, we'll have a hearing on that as well. But we can take that under trial.
Yes, sir.
Okay.
And would object to taking it up in trial. The state could advise this even ad docket. I believe that's in 2 weeks or next week.
I'll give you some information next week on phones. Yes, I can do that.
When are we set for?
February 6th.
So jury selection is February 6th, correct?
Correct. Oh, when is docket call? I'm sorry.
That was my question.
February 1st at 9.
February 1st. So just have it by February 1st so that she has an idea of the time. Okay. All right. We have the motion of levity to exclude various drawings.
Here I can inform the court of a stipulation. The state does not intend on introducing any of the item numbers the defense has identified 94 through 97 in this, we'll just call it this phase of the trial, or guilt phase, as you will. And then if it comes up later, we can address it later, I think.
All right, Ms. Peoples.
Yes, Your Honor. I believe the state's agreeing not to use this in the trial.
All right, so the motion, as far as the guilt stage, the motion of levity to exclude these drawings is granted. Based on the stipulation. Okay, let's move to the motion of levity to exclude several knives collected. These are knives that were collected during a search, I believe.
Yes.
Is there an announcement on this, or do you want to?
Partially, yes, Your Honor. So the intent of the state in our case in chief would be obviously, and I believe defense is also stipulating that they understand the relevance of the crime scene seized, the knife seized at the crime scene, which is identified as item number 62. There were a number of other knives seized from the Fucci Smith residence, numbers 80 through 88. The state does does not intend to introduce those at all.
So that was 80 through 88?
Yes, Your Honor.
Okay,
They were found in various bedrooms in that home.
okay.
There's another knife, she's identified it as its number 127. It actually was not seized from that house. It was taken from Mr. Fucci's girlfriend, I believe, but I'm not introducing a physical knife. What I told Ms. Peoples, my position is, at this point is, and perhaps it's something we can address during trial or I'll have to proffer, but essentially, Your Honor, when the witnesses that identify the murder weapon as his weapon, when they describe or they're asked, does Aiden Fucci have any knives? The answer was very consistent through all three witnesses. He always has 2 knives. He names one picker and he names one poker. They were shown pictures of knives, and ultimately the murder weapon was identified as one of the 2 Aiden Fucci always carries. So that would be the extent of mentioning another knife, and I think it goes to just explain and kind of corroborate that all 3 individuals separately knew that. So the mention of a second knife would be as far as we would go other than the murder weapon in that context.
Right, and I understand that, Your Honor. It seems like there's an agreement on the items 80 through 88, but as to this 127, again, this is a particular item that has no connection to the allegations, so defense would stand on the motion, the objection, that to introduce, similar to what we saw with the O'Connor case, that it's not proper and it has no probative value to introduce weapons that have no connection to the crime that's charged. So to present what the state is suggesting, a second knife is for propensity. It is not being identified as a knife involved with the allegations as charged before the court. So I'd ask the court to advise or to grant defense motion, and that state witnesses are instructed not to discuss any additional knives beyond the one that's directly, or at least state anticipates that's in direct evidence to point some involvement with that knife with the charges before the court. Meaning 127 has no connection other than the allegation, meaning he carries it.
And for the right, so the record's clear, I do not plan on physically introducing that knife. I do not plan on introducing a photo of that knife. It would be testimony only because they were told, law enforcement was told he always carried 2 knives, and when it was described to them, they presented 2 photos to every witness, who then picked between 2 photos which one was named what, and one of those happens to be the murder weapon. It provides context for those identifications, which are going to be very important in this case, identifying that knife to him. And we will not go beyond that. I will not show another photo, introduce that knife, or any other knives found in his bedroom.
And the objection stands, Your Honor. We're still dealing with propensity. For them to show 2 photos to the jury is improper. Or to discuss the
Stated there's not going to be any photos of this second knife.
And
there's not going to be any introduction of the knife.
Right, and Ms.
So here's what we're going to do. I'm going to grant the motion as to items 80 through 88. No other knives afflicted will be admitted or received as evidence. As to the knife identified as exhibit number 127, that will not be admitted as evidence, and it will not be, no photographs will be received as evidence. As to any testimony of regarding that knife, second knife, that testimony needs to be proffered to the court, a reserve ruling on whether or not the court will entertain and allow witnesses to testify about it. But we'll handle that at trial.
Yes, Your Honor.
Okay, so just before you intend to introduce that, don't mention anything prior to, and at the right moment, we can proffer it in the court. We can take this argument again at that time.
Yes, Your Honor.
Motion to compel address discovery and request for an order to depose some category C witnesses. These are identified as 3 witnesses that you're requesting Ms. Peoples to.
That's correct, Your Honor.
Is there an objection to this?
Our position is that they're properly categorized, and actually, I only located A, B, and the third one you see there listed, Carlo Lindo, as C witnesses. I know GH is mentioned in the reports by one other juvenile, and that's been deposed. Our position is they're properly listed. They have no material information about the crime, and the state does not intend to call them, and everything that the state has from them is memorialized in a police report or an interview, and we've turned that over. I understand it's up to the court's discretion, but I believe I don't even see the link as far as Ms. Peoples' case presented on whether these would be witnesses presented at this phase. I think it's more of a mitigation exploration she's doing, but I don't want to speak for her. I suggested, can you not send your investigator out there and I don't know, talk to them? I mean, you can do that without taking a formal deposition and a sworn statement. But
Thank you, Your Honor. So we filed this motion in light of the earlier motion filed, I think it was last November, and granted on a motion to compel disclosure of mitigating circumstances. So in all candor, yes, it looks like these two witnesses, these children, are predominantly towards a sentencing potential litigation, but they've all been discussed by other children that we've deposed. Our office has made efforts to contact the individuals listed here. We've reached out to the state in December about our efforts to locate and depose these individuals. Now, with particularity to the children, the parents will not allow the public defender's office to just sit and talk with their kids independent of a subpoena for a deposition. So it's not that easy for our office to just go knock on doors and speak to people. By and large, with great consistency, the only individuals talking to us are in the office with a deposition and a court order forcing them to show up. So it's a unique case. Yes, normally we would go knock on the door and just speak to them on our own, but this is a situation where we do need the court's assistance. As to Carlo Lindo, this is a witness that is listed by the state who had alleged contacts with the decedent close in time, meaning within days of the offense, but we've never been able to verify that. Law enforcement did speak to him. We are trying to determine was he in contact with her that night, and that's why we need a current address, and that's why we're trying to depose him. So it's our ability to further investigate and literally lift up every rock and make sure that we've checked everything before we have a jury selected in this case is what we're trying to do. And we do need the assistance of the court and the state in terms of a current valid address on Lindo, because we've exhausted our efforts. And then same with the two juveniles listed. It was originally 3, but the state was able to make contact and interview the third, and we have a deposition date set for that individual.
So let me just inquire, so the two juveniles, is there any scenario in which that deposition will be necessary prior to the guilt phase?
If we can have the assistance of the state to at least contact them ahead of time, meaning have some opportunity for defense counsel or our investigator to at least speak to them, I suspect that this would be one of the two individuals we could depose in preparation for a potential sentencing hearing. So to answer the question, if we could at least speak to them, we could set the depo potentially after a trial date, depending on what we learn.
Well, that's what I'm trying to get at. I mean, I'm going to grant your request to depose the third person. As to the two juveniles, I'm reluctant to order a deposition before it's necessary. In other words, for juveniles, if it's something that we need to do before trial, absolutely. But if it's not, if it's something that is not going to be utilized for trial, we don't even know if it's going to be necessary. So my intention would be to hold off on that. We're going to have some time.
There's a lot of question marks in that. I'm just saying, as long as the state, because with all candor, the children and its parents, we can't speak to the kids without the parents, and the parents are not allowing us to speak to the children. So if we can have some assistance just to coordinate that, meaning to have the opportunity to speak to them, interview them, we would appreciate that.
Ms. Dutton, can you facilitate that, at least for a conversation, and then if a deposition becomes necessary, that will take place after the trial?
Sure.
But as far as Carlo Lindo, I will grant the request to depose that individual. So if you'll assist in making that happen so that that can be done. Are there any other depositions that are outstanding at this time?
They're scheduled, yes. If we have, I believe it's only 2 left, but they are scheduled.
So perhaps you can add it to that.
previously provided the exact photographs. The state has already limited our presentation to Ms. Peoples with the numbers as they correspond to our electronic disc. I have a copy for you to pass out to review. I don't know her specific objections yet, but we can discuss it as she reads. And just as a general information, we had 204 autopsy photos and I believe 10 x-rays. I've limited it to, this contains about 49 pictures and 1 x-ray. So I went from 204 down to 49.
All right, are there specific objections from the defense as to, do you have a copy of this as well?
Yes, Your Honor.
Okay, are there specific numbered ones that you object, or do you object to all of them?
No, what I could do is it's really three categories of objections. So, and I will, it's not to all, Your Honor. It is to in terms of the nature of the cause of death, that there are two areas that are involved, and that the photos of the injuries beyond the back and to the head, defense would have an objection to all of those photos as not pertinent or probative for the medical examiner's testimony as to cause of death. So that would be the first objection, Your Honor.
Can you give me the numbers of those photographs, please? So what I intend to do is I'd like to know exactly which numbers you object to. I'm then going to take a break, I'll take a recess, I'll then look at these photographs, and then I'll come back and then we can discuss them individually. But I'd like to know which specific ones you were objecting to, because that's the way we can go about this.
All right.
And I did also put dividers. This is for the court purposes, not exactly how it would appear testimony-wise. I'd put dividers, breaking them up, how they would be presented, and have already conferenced with the medical examiner, and they're broken up in photographs, how the report reads by section. So if that becomes necessary for Your Honor to see at one point, I have a copy of the autopsy report as well.
And Your Honor, I usually go through them individually, so I didn't have a set number prepared. So I'll just quickly give you that.
That's fine. As you're going through, just tell me the number, if you would, and then I'll just write those down so I know specifically which ones to look for.
So do you understand why 625, I know the medical examiner isn't present, but based on the deposition, I have an understanding of the purpose of that. So the objection would be to 702 for no probative value. And then 720 is cumulative.
20, 20?
720. As well as 724.
Also cumulative?
Cumulative, so 720 and 724 in light of 703.
Okay.
So 860 as cumulative in light of the x-ray. And that would be two later than that. To the selected photos under head and neck from 738 through 745. The objection there, Your Honor, is that
Hold on, let me go back, I'm sorry, so, say that again.
from 7:38 through 7:47,
Okay.
that the fatal injuries are, they're present, Your Honor, but then there is the additional, so that it's cumulative, meaning we're seeing multiple images with the overlap. But I do
So that's,
understand.
so you object to 738.
It sounds like you object to all of them.
So and to be clear, 738 through 747 is showing different angles, and there are some different injuries identified within it, but the majority, and I apologize, Your Honor, the part I'm getting to is that there's overlap. So we're seeing images that are not fatal and are not necessary or probatively valued. So, but it's not for me to tell the state which ones to pick. But that's the cumulative comment or the cumulative argument there, is that we're seeing a lot of these injuries that are non-fatal. And defense would argue that if it's a non-fatal injury, that the probative value is low and it is not necessary to present that to the jury. So it would be one objection to all of those that I would not repeat for each one. Does that make sense?
Am I arguing this now or later?
In a minute.
Okay.
And what other objections?
In these photos that the decedent's hair has been removed and
Which numbers?
the same one, 738 to 747. So I'm just recognizing that there are photos that are more gruesome than what's been presented here.
So is your objection to cumulative or is it?
Cumulative.
Okay.
But specific to 860, it is cumulative in reference to the x-ray, and that it is highly prejudicial, and that the material information that is represented in this photo can be garnered in terms of the x-ray and the testimony of the expert.
Okay.
Turning to 813, it's my understanding the state's going to show the cropped version on 813.
Yes, I showed the original photo, Your Honor, for context. I went ahead and cropped, so you only see the skull and not the background of that photo.
So then 817 and 818 would be, the argument there would be cumulative to 813. Meaning the expert's testimony on 813 would address what is seen and identified in 817 and 818.
Want me to respond now or later? Okay.
Then to the back. Defense would just stand on the objection as represented in the motion.
You said the back, what numbers are those?
790.
Should be a singular photo right after the divider that says overall back. Maybe?
Okay.
Yeah.
I'm sorry, so your objection to that is just that they're,
I'm standing on the motion.
okay, any others?
Then the next section is upper back and shoulders.
What number is that start with?
750.
750. Right after 790.
So defense would object to numbers 750, 777, and 780 as having low or no probative value. These are photos of injuries that are not lethal based on the deposition of Dr. Fulcher. 784 and 785, defense would stand on the motions presented to the court. And then 808. Your Honor, defense would argue that Dr. Fulcher does not need this photo to describe the injury to the internal organ, and that he can testify to these injuries independent of this presentation.
Okay.
So standing on the motion again. Turning to 7. One moment. Turning to 802, Ms. Marcus Croft. And 804 would be, based on the deposition testimony of Dr. Fulcher, that these photos are being introduced, and the state can correct me, to show the progression of the injury, meaning from exterior to interior to the organ. Still in light of that 802, similar to 804 and the previous photo of the other organ, that these are not necessary for his testimony and presentation, that these specific to 802 is a gruesome photo, and I do appreciate that it is Brincroft, but he can still testify and explain the nature of these injuries based on the earlier photos of the exterior of the decedent without having to look at these interior photos. Turning to the right lower back area. These are not representative of fatal photos, or fatal injuries, I should say. So defense is still standing on the motion and addressing the issue that this is not an injury that is, the state needs to prove up with their case. It's not a fatal injury anymore. So the last block is marked as defensive. And that would be 725 through 760 in the presentation to the court. So defense stands on the written motion before the court on all of these, that these are, these photos of the hands and arms are repetitive in nature, that one or two photos of each side of the entire hand would cover these issues. If the court was inclined to allow these defensive, what the Dr. Fulcher has described as defensive wounds. That the charge before the court is first to remember that his description in the deposition of these wounds is that none of them are fatal, nor would they cause loss of life. So the charge is a first-degree homicide charge. He's unable to describe in terms of sequence and order of any of these injuries, which calls into question how you can describe them as defensive if he's unclear in the order of them. So defense would object to that final grouping of photos and stand on the written motion before the court.
All right. All right. Steve?
Okay. Do you want to start back at the beginning, Your Honor?
Yes.
Okay. So the purpose of 701, 702, and 703 are overalls of the decedent, how she appeared after being washed. We never attempt to show how she appeared upon the bag being open. So they are cleaned up. They're overalls. They show perspective of wounds that will be discussed moving on. She also has her hair in these photos, and it shows her as she appeared. The 720 and 721 724, Ms. Peoples objected to cumulative. They're minor injuries in this case, abrasions to her knees, but they're just close-ups, and I don't believe that you can see them as, I think Ms. Peoples said she objected in light of 703. You definitely can't see her left knee injuries in 703, and really what's going on in 704. So those are just close-ups of mere abrasions to show those close up as superficial. That's how they'll be described, but obviously they paint a picture of what could have occurred during this crime. Yeah, you move on to the next step. Okay. I believe she said 738 through 7.
There's 860 first.
Oh. Well, she jumped ahead in the photos, yeah. I'm just... Okay, I'll go to 860. So 860 is a actual photograph of, and there were 3 or 4 of these, but the state picked one, the closest up one, depicting the tip of the knife blade that was removed from Tristyn's scalp. That evidence is extremely important in this case, as we expect a member of FDLE to testify that in fact did match, an exact match to the murder weapon we found that will be attributed to the defendant. It is a visual representation of what was taken from her head. And yes, there's an x-ray to show it existed, prior to a medical examiner finding it within her skull, but it's not cumulative, it's just 2 different representations. The x-ray shows it was there before the body was touched and opened, and then it shows the recovery of that. That's an item that will come into evidence in the chain of custody from the medical examiner's office to the crime scene technician with St. Johns County will be established, and that's a photographic representation of them removing it from the body. Back up to the first set, essentially, I think her argument, I'm not sure, she said cumulative.
747,
Cumulative, Your Honor, obviously there's a lot of wounds in this case, and the medical examiner's office did a very good job of trying to take photos, and I also, when you see cropped images, I'm cropping out as much repeats as I can, but for instance, in 738, you get a lot of the side wounds, but you don't see wound 31 very well until you go to 740. And it's just moving around the head. So that's the only 2 photos I show of that first set of injuries. The autopsy report is broken down into groups, and so it's not on this slide, but the medical examiner will testify, okay, we've got wounds 23 through 33. That's all on this forward of the ear, right side of the head. Well, the only way you can see 31 and 32 is if I use 2 pictures. The first picture shows a majority of them, and then the next picture shows the other 2. And peripherally, you can see the first ones I just showed, but it's not cumulative in a prejudicial way. It's the only way I can show the remainder of the images. And then the same thing, you move on to the next set. Those are behind her ear. It's wounds 72 through 81. You don't see them all here. So it goes all the way to 80. It's 72 through 79, and then the next picture is 80 and 81. So I'm trying to pick out every single wound and show every single wound without too many duplications. And I thought it was a very good representation of that, and there's not a lot of duplications in this overall presentation. As to the larger argument, which goes, well, I'll wait on that. She didn't object to that in this case, on this set. As you move around, you see the back of the neck, we move slowly over there. 744 is the only photo I show of that view. You go around the head. I don't see a lot of duplicates in that first set at all. If she can point to something she believes is overly prejudicial due to cumulative, we can maybe address it individually, but
And perhaps what the are seeing additional unmarked at that juncture, for example. And then 771 again, we're looking at marked and then unmarked because it's broken down by region is kind of what the medical examiner did. So I do understand what the state's trying to do and appreciate the effort to reduce the numbers, but it is still cumulative if we are using this particular photo, turning, for example, to 771 to point at 80 or 81 when we're seeing additional injuries to another region of the back. So I'm only interrupting because the state asked.
No, you're fine. And I can explain too, like, I think the state took great care in trying to only show each one once. There are a few times where it is impossible to not do that. But like in my presentation, Your Honor, so Your Honor's aware, I showed 768. So photo 771, which has wound 80 and 81 in it, wound 80 and 81 are under the white placards in 768. So it's under 77 and 76 right there. So when I show it in the presentation, this photo pops up first, and then 771 just comes right on top. It's almost like a mirror image to just show. I can't physically show you because the next two wounds are under these two white placards. There's no other way than to show this photo. So that's an example of that. And I tried to do that the best I could throughout this presentation. I believe the next one to 817 and 818. Right. So I don't believe those are cumulative. 813, the cropped image, is one view of the tool marks or injuries to the actual skull, and he'll explain the depth and some superficial, some not. 817 and 818. 817 is a different side of the skull. So that's the right side. It's a different image you don't see in 813. And then 818 is the interior of that. And that injury right there associates with the tip of the knife blade and the amount of force used to break a skull, the thickness of the skull, and everything else that the medical examiner will describe. So there's absolutely a probative value. 790 is just an overall for placement of what we are to talk about in the following images. It gives context. It was the only way to give context to all of the back injuries. I don't think it's overly prejudicial. She's washed. I believe in, sorry.
777,
I think she objected to these based on, was this a low, I wrote down low probative value because they're not fatal, was that your argument? So I want to address that in general with all of these images. Dr. Fulcher, there are there are 6 injuries that he would testify by themselves would be fatal. She just got that one injury, that would be fatal. He did testify, however, even without those 6, anyone, like those 6 don't exist. All of these wounds in totality, even though not individually, without treatment, would be fatal. That leaves 98 other bleeding, hemorrhaging wounds, in addition to the trauma to the head. So he did testify that all of the wounds cumulatively are fatal, even if the 6 individual fatal wounds were never inflicted. So in addition to that, Your Honor, the standard, as Your Honor knows, the standard for showing these photos is obviously there has to be some probative value. The standard is not whether they're fatal. That's never been the standard. And the probative value to showing all of the wounds, not just fatal wounds, is obviously it paints a picture for the scene, the crime that occurred. Premeditation will be an issue in this case. And one way to prove premeditation, we have multiple ways in this case, but one way is through the act itself, the amount of time, a struggle that may have ensued, which will also play into the argument on defensive wounds. So just because a wound isn't lethal doesn't mean it's not relevant and probative in describing a crime that occurred, whether that crime was premeditated, and it plays into length of time that crime could have taken and a number of other things. So that's the state's position as far as non-fatal wounds not being probative.
All right, how about 784 and 785?
Is there a specific objection to?
Standing on the motion.
I'm just making sure, I mean, I believe this is the photo that, it starts the series of numbers. 106 is one of the fatal wounds. If you go to the next picture, 108 is one of the fatal wounds, 103 is one of the fatal wounds.
What are the fatal wounds? What numbers?
103, 106, 108. 100, 102, 109. And so this series of photos shows those fatal wounds in that series of 3 at various places. Her objection to 808, I guess she argued that testimony is enough. I mean, along that argument, then that would mean that medical examiners never got to show photos of what they were describing. Again, that's not the standard. The standard is to show that what they are testifying to did in fact medically happen. It's not just the injury on the lungs that the medical examiner is prepared to testify to. He's also prepared to testify about the color and what that meant as far as whether she was still breathing, conscious, and alive, which again plays a part into how long she may have lived through this struggle and attack. So that would be an additional reason for the lung photographs, Your Honor. And I selected one of the left and one of the right, not all of them. There's multiple injuries in these lungs, and I only show one left, one right. Photo 794 has a fatal wound 100 in it. I don't remember where our next objection is. 802?
802.
Okay. Again, this was her, it's not necessary. Testimony is enough, Your Honor, that's not the standard. In addition to showing the wound travel from the exterior of the body to the interior to the lung, much like the lung color also tells the medical examiner things. In 802, the hemorrhaging you see internally tells him things like whether the decedent was alive, breathing, which therefore would allow the heart to pump and blood to be pooling where you see it pooling there. So it's a secondary reason for that. So,
it was also 804, same argument.
yes, yeah, same as before, is the lung.
Then in 80, I understand 802 is cropped, but if it could be cropped further, perhaps on the right-hand side, would address the gruesomeness of the photo.
You mean the top? Or what are you talking about?
I mean, if you want to see.
Yeah, I can work with 802 a little bit more, Your Honor, that's fine.
Stipulation table further crop, photograph number 802.
$789, I think that was these aren't fatal, so therefore they're not relevant. Objection.
Correct.
I've already spoken to that.
How about 725
And then-
through 760?
Right. Again, Your Honor, just because a wound is not individually fatal, doesn't mean it's not probative of how this crime occurred for the basis of other arguments made. So the medical examiner, one, testified that all of these wounds, if left untreated, even without the fatal wounds to the body cavity and the lungs, would be fatal in and of themselves due to blood loss. You can see that based on the amount and the size and whatnot, depth, things that will be described of all of these wounds. And again, defensive wounds go to show what is going on in a crime and how long Ms. Tristyn Bailey may have struggled, which will all go to premeditation arguments made by the state.
We'll take a 15-minute recess. I'll review the photographs, and then I'll come back and show you. Anything else from the defense before I do that?
No, Your Honor.
All right, very well. We'll be in recess.
Court's in recess.
Photographs that have been selected for introduction during the trial are not, could not be considered cumulative. There are, I believe, the number was 106. Is that correct? State the number of 100 and how many?
Total, there were 204 originally.
No, the number of wounds.
114.
114, thank you. That requires the state to show multiple photographs that, while the court typically may limit the number of autopsy photographs in this particular instance, given the sheer number of wounds, the court does find that the prejudicial value or the prejudicial effect of showing these photographs to a jury is outweighed by the probative value of the photographs themselves. And so the court is going to allow the state to introduce all of these photographs that the court has reviewed today. Do you want me to probably make this part of the record under seal?
Probably, as long as it can be sealed.
It needs to be sealed.
Oh, you're talking about the
For
actual.
today, yeah, this
So
packet
let's
for receipt.
Defer to the state if they want that.
We'll mark that as exhibit, I guess, for the state,
Yes,
and that will be kept under seal.
yeah, under seal, please, because otherwise an appellate court can never look back at what our record was. One moment. That's all the state has, right?
Anything else to do with
No,
this?
Your Honor.
All right, we have, we set for a final pretrial, we just have our docket set, call reset one in this case.
I believe the clerk announced the date is February 1st.
All right. So that is enough of that. I'm going to show you guys a short kind of newsy clip. So to prevent kind of having to play one of these other videos, I'm going to kind of sum this part up. So the defense tried to delay this trial. Due to this 6-member jury panel decision that was made. So the short of it, and I'll read this, but the short of it is that they filed with the, I believe it was the 6th District Court of Appeals, 5th District, sorry, 5th District Court of Appeals. Defense filed a motion, but she screwed up and forgot to mention in that brief and that motion that this was an emergency. So because of that, this could have potentially delayed this an additional month. And instead of kind of canceling that motion and refiling an amended motion properly with the, the emergency information in there, she asked the judge for a stay. So basically, so this is what it all says. The motion for continuance of the jury trial was filed Wednesday morning, so yesterday, just hours prior to what was set to be Fucci's final court hearing before the trial, which was scheduled to begin Monday. It centers around the judge's decision last month to grant the state's motion for a 6-member jury and reject Fucci's defense attorney's motion for a 12-member jury. In the motion for continuance, Rosemary Peoples, that's the public defender, states the 5th DCA has requested a response from the Attorney General in 20 days with a deadline of February 20th and allowed an additional 10 days for the defendant to file a reply. This motion is made in good faith with no fault to Aiden Fucci. He had no control on the timing of the motions filed by the state. The defense team moves to continue this case pending the ruling of the 5th District Court of Appeal. During Wednesday afternoon's pretrial hearing, which lasted 11 minutes, Fucci's lawyer argued the issue is going to be taken up by the 5th DCA, so the stay should be granted. The state noted the 5th DCA did not issue what's called a show cause order, which would have halted the trial. The defense lawyer acknowledged it was a mistake by her to not file that writ as an emergency. She still can, but it is unclear whether she will. Now, if that happens sometime between today and tomorrow, we may not have a jury selection Monday. The judge said that for the 5th DCA to accept the writ as an emergency, it would have to certify a conflict with existing law. That would land the argument before the Florida Supreme Court, which would mean an extensive delay in the trial. The judge said that was unacceptable. Smith said there is no harm to Fucci by going to trial next week. The judge said that he wants the proposed jury instructions submitted by 5 p.m. on Friday, so tomorrow, and jury selection is set to begin Monday. So again, I put in the comment section, I still cannot find a single article on what time court starts. All we know is that there are a couple of local media outlets that will be in court filming. Again, I have no idea if it's live. I'm expecting it to be live since these pretrial motions were. And again, I've said this before, Court TV gets the contract for all of these trials, and then their feed goes out to like Law and Crime, their own channel, Court TV, different media outlets, all of that stuff. So, and then that's how we end up picking these things up too. So I have no idea. And obviously without my phone, I can't call my buddy over at Court TV to be like, hey, do you know if the Florida Court TV section is going to be there? I have no idea. I can't. I'm so fucking limited right now. It's not even funny. So, right now we're expecting to be live Monday for jury selection, which is expected to last 2 to 3 days. We're going to get into some jury video here because this is where I was talking about earlier, this very unprecedented move by the public defender's office. I've never heard of something like this. It's bizarre. So Fucci, who's now 16, charged with first-degree murder in the stabbing death of Tristyn Bailey, who was 13. Aiden was 14 at the time. He could spend the rest of his life in prison. As a juvenile, when the offense occurred, he's not eligible for the death penalty. He's been in the Duval County Jail because St. John's County Jail does not have a juvenile wing. So we said that earlier. The defense also expressed concerns during Wednesday's hearing that the number of preemptory challenges or ways to object to jurors would be reduced with a 6-person jury. The judge said that's not true. He said Fucci is still entitled to 10 preemptory challenges because he's facing life in prison. So this defense attorney seems a bit weak, honestly, kind of listening to her. I'm kind of sensing a little bit of cattiness with the female state's attorney, kind of some derogatoriness towards Attorney Peoples, because the state keeps referring to her as she. Maybe I'm just reading it wrong, but it's kind of how I'm sort of taking it. So it's a little bit derogatory. There's no, Attorney Peoples or defense counsel or counsel. It's just she. So kind of a little weird. Let's pull this up. So I want to play this news clip for you guys. So this kind of tells us how Aiden Fucci has behaved in jail. So we'll play this, so we're not doing so many back-to-back pretrial hearings.
Teenager accused of murdering his 13-year-old classmate has been threatening and extorting other teen inmates, according to jail officials, with new material we've just received. According to records obtained by First Coast News, Aiden Fucci has threatened violence against correction officers and other inmates and allegedly bragged about his crime. Tonight in our top story on First Coast News at 5, Fucci is charged with murdering 13-year-old Tristyn Bailey by stabbing the St. Johns County teenager more than 100 times. He has pleaded not guilty. Tonight on Your Side's Rich Donnelly joins us now from the newsroom with how one of the outbursts could be used in next month's murder trial. Rich?
Yeah, Jeannie, 16-year-old Aiden Fucci goes on trial for first-degree murder next month, but his alleged history of violence against other inmates goes back more than a year. In fact, according to jail records, on Christmas Day of 2021, Fucci admitted to stabbing and killing a girl. Fucci is being housed at the Duval County Jail while he awaits trial in St. Johns County. According to jail officials, on Christmas Day of 2021, officers used a taser to break up a fight between Fucci and another inmate. 1 month later, an inmate told officers that Fucci has been threatening inmates and said he would stab that inmate. The inmate said Fucci claimed, quote, "He's real because he stabbed a girl face to face and took her life." We spoke with a local attorney who said that alleged admission could be used against Fucci in next month's trial.
It's not a violation of any Fifth Amendment right. It's not made to law enforcement. It wasn't made in response to questioning. It's a spontaneous statement. It can absolutely be used against him. Now, he could take the stand, or his lawyers could argue, look, he's in jail. He's trying to act tough. He might admit or say that he did something that he didn't really do, just to make him look more dangerous because he has to survive in this very tough environment.
Coming up at 6 o'clock, we'll take a closer look at more of the discipline issues facing Aiden Fucci, including allegations that he's bullied and threatened other inmates. Reporting in the newsroom, Rich Donnelly, First Coast News, on your side.
All right, so there is some of that going on in the jail. My old ass dinosaur computer is fucking up right now. I had the jail stuff. So jail reports, this fucking thing. Jail reports obtained Thursday from the Jacksonville Sheriff's Office show Aiden Fucci, the teenager charged in the murder of 13-year-old Tristyn Bailey, has been involved in multiple disturbances while incarcerated at the Duval County Jail. Records reveal, among other things, he's gotten into a fight and threatened to kill inmates, corrections officers, and their families. According to documents, on December 25th, 2021, a corrections officer witnessed Fucci hit another inmate, and the other inmate punched him back multiple times. People said the other inmate was stun-gunned and that Fucci told JSO he was being extorted for his commissary items and bullied. When asked why he didn't inform the officer, the report says Fucci stated, "I ain't no snitch." The report states no officers were injured. After that fight, the report states Fucci was placed in solitary confinement. A report that was filed January 25th, 2022 makes note of threats that Fucci reportedly made while in the jail and mentions the fight that occurred on Christmas Day in 2021. The report reads that Fucci has been relentless in his threats against two inmates. One of those inmates told police, the report reads, Fucci been saying he gonna stab me up when he gets back to GP, which is general population. He be telling everyone in the dorm that when he get out, he gonna find my people and stab them and take pictures. He go around saying we all, I'm assuming this is pussies, because most of us in here for shooting someone and killing them. He says he real because he, I don't know, it starts with a B, because he stabs a bitch. That's what I'm assuming this says. Because he says he real because he stabs a bitch face to face and take their life. It's like he get high off it or something. So that's what the article says and how it's written. Further investigating, according to the report, shows Fucci made several threats against other inmates and staff members, including when an inmate told police Fucci threatened someone, saying, when he gets out of the box, he's going to stab him up. What's up, Charlie? The report makes note of an incident on January 20th, 2022, when Fucci was found to be extorting commissary items from an inmate by using fear. When officers attempted to obtain the commissary items that Fucci extorted, the report reads, he became highly agitated and made threats against the officers' lives that were getting the commissary items back for the other inmates. The report adds that officers said inmate Fucci made threats to kill our families while beating on his cell door in a loud, vicious manner. Two other incidents mentioned in reports. On October 28, 2021, corrections officers noticed Fucci's eyes were baggy and discolored. The report states he first told them he'd been beaten by St. John's County deputies shortly after he was returned to the jail because he wouldn't get out of the car. He reportedly later said that no one hit him and that he was just not sleeping well. On October 5th, 2022, a report states corrections officers found an excess of books and magazines in Fucci's cell during a shakedown. Fucci reportedly refused to let the officers remove the items, and he was pepper sprayed and later placed in a restraint chair. An attorney, Shannon Schott, who's an attorney and juvenile law expert, reviewed the documents, and she states, this is the reality of children being incarcerated. I think it's important to remember that these are all children who are put into a box and they're given very little supervision and very little resources to deal with the fact they're charged with serious offenses. When asked if it's possible whether the documents could impact the defense, Schott said there would be a serious question from the state attorney as to whether these witnesses are credible. So he's obviously causing a lot of issues in the jail. All right. Let me pull up this. Hang on, I gotta find which one. I think it's this one. Just give me a second. Let me listen to this. Oh yeah. Okay. So I want to play this one. So this is a big argument, right? And we all know with media coverage of the trials, all of these types of things, that people start hearing stuff, and then the rumor mill starts, and social media, and all these things, right? So it's always an argument on whether or not it's a fair trial, trying to move, get change of venue, all these things. So we're going to listen to the argument about how the members of the community are actively doing things so they know about the trial. But we're going to hear what the public defender's office did, which is fucking bizarre. Bizarre, chat. It's bizarre. So let me pull this up. Oh, see, now I'm on a different screen and everything got fucking jumbled around. This one.
All right, we are back on the record in case 2021 CF 835. Everyone is present. Ready to move to the motion for change of venue at this time?
Yes, Your Honor.
All right.
Your Honor, the defendant is moving on a motion for change of venue from St. Johns County to outside of the Seventh Circuit. I will not go through each of the exhibits that are provided to the court, but it's the intent now just to highlight some of the issues that are presented within the motion and the exhibits. So we have certificates of good faith from the defendant, from counsel, and from members of the community. In this particular instance, on this instant case, it starts on May 9th, Mother's Day. An Amber Alert goes out throughout the entire community. So all of St. Johns County is aware of this case. And that day in particular is very poignant in how this case is publicized and the media attention to it and the discussion in the community about this case. My client, Aiden Fucci, was arrested. And again, there's a media blitz in terms of his image in the back of a police car. And so Snapchat images are then proliferated amongst the community. And yes, it does go beyond St. John's. There's a lot of attention, even now in court. There's media here on this particular case. It's not the only case or the only homicide case that the media shows up on, but the difference here is in terms of the quality. So within the exhibits before the court is a summary of some of their.
I think Ms. Dunn's having a hard time hearing you. Just try to speak into that microphone. I can get that's fine.
Okay.
All right. You continue.
All right. In terms of the news articles, so at the time of this this motion was filed, we had already exceeded 150 news articles on this case. The greater weight of those articles are coming out of the Jacksonville media. They're permitted to do that. There's nothing illegal with what they're doing, but it is drawing an inordinate amount of attention to this specific case. So, in addition to that, there is Sheriff Rob Hardick. This isn't the first or the only case that he's had media interviews on, But again, he's had several on this case. And then his statements specific to this case are then proliferated again or placed out there in St. Johns County. It's not just someone's neighbor or some random individual. This is someone that received a large portion of the vote in St. Johns County. His words and his opinions carry weight. And they're out there for all to hear. St. John's and Duval. It's not to say.
When were those statements made? What was the last statement made by Sheriff?
I have a transcript here. I want to say it was just around Mother's Day of this year. The court gave me a original to double check.
It's not dated.
It's not dated.
I do have the video clip, and I will get that answer to the court this afternoon or in a short time from this. But I do believe it was around Mother's Day last year, where he sat down with Katie Jeffries and had a discussion about this case. Nothing illegal in that sense. But for when we start to get into the specifics and the facts of the case, or I would say improper. So we have Hardwick and then R.J. Larissa, the state attorney. Now in other jurisdictions, it's not uncommon for the state or the public defenders or the defense attorneys to file motions, protective orders to prevent the sheriff and the state attorney from making public statements about the case. Seventh Circuit, we haven't done that. That's been my experience with the state attorneys, at least the line attorneys, for example, Dunton and Mr. Johnson, that any communications that they have with the media is post-conviction. They're usually pretty tight-lipped about the facts of the case before the case actually goes to a jury trial. It's not to say that they never say anything, but I've never seen or experienced this level of detail from the state attorney's office. Again, R.J. Larissa overwhelmingly got the vote throughout the circuit. So again, this is an individual that carries weight and his opinion matters in the community. So to have these two public figures speak not just their opinions on the case, but details and facts to the case, it taints the well in terms of the jury pool that we have.
Do you have the dates or the last time Mr. Larissa spoke about this case?
I do not right before me right now, but I can get those dates to the court.
All right.
So I will provide the dates for, and then with both of these individuals or these public figures, they also have Facebook pages where they're also opining and providing facts about the case. So I don't believe that's in here, but I will get all those dates to the court. So in this particular instance, it's not just the overwhelming opinions of Sheriff Hardwick or State Attorney Larissa. The media attention that has been brought to this case in terms of the vigils, nothing new. Whether we're looking to a case as old as the Colley case or others, where the community will have some form of vigil. The difference is to the terms and the numbers. So in this particular instance, there were vigils at the schools, there were vigils in that specific community of Durban, there were vigils that were live streamed at a church, where large portions of the community attended and or watched. And then it continues in terms of the fame or the notoriety of this particular case is so great that there's even fake pages on Amazon where they were selling images of the decedent. It was shut down. But it's just, that's how big the case is, that there's so much attention to it. Now within St. Johns County, the vigils and the attendance to them continued after in the forms of ribbons. So you have members of the community purchasing teal ribbons and decorating the community in remembrance of the decedent. School children with their backpacks, young girls with ribbons in their hair. So you'll see, and the state, they're well aware because we brought this up in several of the depositions where people where students and teachers discussed their awareness of the ribbons in the community, their wristbands, ribbons in the hair, and things of that nature towards fundraisers. Some towards the family, others to set up scholarships in her name. Again, there's nothing improper with this, but we're now talking about a change of venue. And the attention and the amount of ongoing attention, and yes, it was stronger in the beginning, but it still continues on. That even today in November or December, I should say, of 2022, there are still teal ribbons out there. Businesses with teal ribbons. There's nothing improper with that. No. The issue is that all this attention, whether it's the number of stab wounds as described by the state attorney, the fundraising that's going on, taints our ability to pick jurors that are wholly unaware of the facts of the case.
Well, why is that the standard? Wholly unaware of the facts
That
of
is
the
not the
case?
standard. That is not the standard. It's to whether they can be fair and impartial. And to say individuals where the attention is this great in terms of the media attention, in terms of the ribbons that are placed around the community in her remembrance, that in this community of St. John's, the defense is arguing that we can't get a fair jury. Now, just last week, there was another teenager. Anthony Fox was convicted. In that particular instance, Anthony Fox was a teenager. The decedent was a teenager. And in that particular instance, it was 120 stab wounds. Very little media attention on that case. There isn't and yes, it's in Putnam, and Putnam's a smaller county, but the Putnam cases are reported out of Duval. So the issue in terms of moving is because of and I have the circles in there showing the media reach. This is not the first case where the media is giving a lot of attention, it's the volume of the attention that they're giving. So whether it's a case just last week where it's 120 stab wounds, we don't have the media attention on the local sheriff or the state attorney or on the news on the regular. In the sense that whether we come in here for a pretrial hearing or ask for a continuance, there are hours or a lot of time, I should say, dedicated to each hearing we're in court on this case because of the media attention. To the point that salient facts of the case are well known in the community. So pretrial publicity in this instant case is to the point where the argument is that we cannot find impartial jurors who are unaware of the facts of the case. Jurors, whether it's in Putnam, because even in that last case I just referenced, Anthony Fox case, the commentary even in Putnam is referencing the Fucci case in the conviction on Anthony Fox. In here, the defendant is facing a potential sentence of life. So there is case law that's provided that Mr. Aiden Fucci is guaranteed a presumption of innocence. That has been thoroughly done away with by the statements of the state attorney and the sheriff. He has a constitutional right to a fair trial. And it is the position of the defense, in light of the media attention and the media attention and the words of the sheriff, the state attorney, and the ongoing commentary by local attorneys. It's not only local attorneys, but just the ongoing commentary about this case, that Aiden Fucci in this particular county cannot get a fair trial. And because the media attention is from mostly 4th Circuit and 7th Circuit, that's why we're asking to have the case moved out of the circuit.
Explain that to me, because Volusia County is in an entirely different media market, are they not? All the reporting for that for Volusia County is out of Orlando, is it not?
Yes.
So why would Volusia, if I were to grant this, why would Volusia not be a reasonable alternative?
Well, then we turn to a similar situated venue, and I provided the census data showing that the distinctions between the counties with St. John's. Now, let's pull that up. So looking at exhibit number 9, and I've given you a couple of examples for Bar and St. John's, but and Volusia.
I'm sorry, which exhibit is this?
Exhibit number 9. So there are distinctions in terms of the population. Now, the greatest distinction of all is that St. Johns County is the wealthiest in the state and one of the most educated in the state in terms of the amount of people with bachelor's degrees and beyond. So those distinctions are one of the reasons why we would say that Volusia is not similarly situated to St. John's. But to the media question, yes, it would be less in Volusia. And they would have a greater population density, meaning more individuals present that would give us a better chance of finding jurors that are unaware of the facts of the case.
And that's not the standard. Unaware is certainly not the standard.
Correct, it's fair and impartial. But in Volusia County, we're also dealing with the effects of R.J. Larissa, that he's voted in by members of the community of Volusia, overwhelmingly. And his words, his description of the offense in terms of number of stab wounds and his description of those stab wounds are known even in Volusia County. I would say that his words would have more attention or gain more attention in Volusia County, whether it's his Facebook page and things of that nature. So we're still dealing with similar issues that it's not just the media, but it's the words of these individuals that carry a lot of weight in the community. And yes, the question is, can we get a fair and impartial jury? And it is our position for the defense that we cannot in this circuit. We clearly cannot move forward. And that's why we're trying to have it moved out of the circuit for those reasons. And then again, I know this is an extraordinary motion because it's usually not argued until an attempt is made to pick a jury. I know that. And it's been over my years of practice to wait and see. But I've never had a case with so much attention before. I've never had a case where even the defense continuance is on the local news. I've never had a case where the sheriff is having multiple interviews with local media and the state attorney is giving the level of details provided to the local media.
Do you have examples of cases that where the venue had been changed prior to an effort or an attempt being made to select a jury?
I do. I don't believe I cited it in the motion, but I do, Your Honor. And I'm sorry to have to come back in a moment, but I can answer that. I believe it was a Cooley case. I didn't cite to it, but it's C-O-E-Y. Was moved in a similar instance where the community on a whole was aware and had fixed opinions about the guilt of the defendant. And the population in that community was smaller, and that's why he was moved in terms of everyone has opinions, everyone's heard about the case, and it's a very small community.
Do you know what county that was in?
I do not, but I can get that to the court, but it was a smaller county in terms of numbers smaller. Now, and the other side of that would be an example of the Cruz case, where that was, the publicity on that went nationwide, but it was in Broward County. Population in Broward County is well over 1 million. It took several weeks to pick a jury, but they had a population large enough that, yes, they had an ability to find jurors that could be fair and impartial and weren't aware of the detailed facts of the case, didn't have children in attendance at that local school. In this particular county, the population is, by the last census, a little over 220,000 persons. We're not dealing with a population density in the millions.
St. John's County?
Yes.
It's 292 in 2021, and I'm certain we're over 300,000 by now.
We were closer to 300,000 at this point.
I'll go with 300,000 by the court in the state. It's a rounded off number. If it's still not in the millions, and we're still dealing with a case where just about everyone in the community not has only heard about it, but has an opinion about the case, a fixed opinion about the case. And that's why we're trying to, in efforts to.
What are you basing that statement on? I mean, when you say that people in the community have a fixed opinion, how can you state that? I mean, I understand the pretrial publicity, but how can you state that the community has, we can't find, enough jurors to have open minds before hearing all the facts and evidence?
Yeah, again, it's the exposure. It's the exposure in terms of, it's not only that they know his name and have the images of him in shackles walking in and out of court. It is not just that, but it's those images and the opinions that he's guilty. It's those images and the opinions of the sheriff and the local state attorney discussing what they've distinctly said are the actions of Aiden Fucci in causing the death of Tristyn Bailey. So then the commentary that you'll see, whether it's on Facebook or any of these local articles, are discussing his guilt and their opinions on his guilt, being Aiden Fucci. And that's within the community of St. John's and SD12. And I can provide, I've given 100 articles. I want to say we did print out close to 150 articles, but I can provide a commentary on those articles also, because I did not do that.
You're talking about the user commentary?
Yes, sir. So we do have the affidavits from those individuals in the community that are attached. And then just looking to the example that we had with change.org, which asked for a petition to have this case, have the Aiden Fucci charged as an adult. And the numbers on that out of, in terms of the overwhelming response. It's just, in terms of the numbers of people opining on this case, even asking for why isn't he getting the death penalty, or some of the commentaries on this case, where he hasn't been convicted, a jury hasn't been sworn, facts have not been presented to a jury, and to say that he could get an impartial, fair and impartial jury in this county, no. And I do understand the court's interest in potentially, even though the court hasn't said yes or no, in potentially some of the minutia. But I do, it is our opinion that because of the attention, because of the individuals that have brought attention to this case, we need to take it out of the circuit. If it went as far south as Dade, that would be a wonderful thing. But if we could at least get out of the circuit, almost all of the concerns, I believe, would be remedied. Because then we're out of a circuit where individuals had gone into a voting booth and chosen between Hardwick or Larissa. Gone to a circuit where the news, every time there's a hearing, highlights this case. And I actually have to correct that. Even when we're not in court, in between court dates, there'll be news 5 minutes and sometimes longer discussing this case. So we're asking for an opportunity for a fair trial, a constitutional right that he has to a fair trial, and then he would have an opportunity for effective assistance of counsel, where even some of the motions that we file or don't file is impacted by the media attention on this case. So if we could at least know that we're now out of St. John's County, out of the circuit, it would also free up defense counsel and our defense of the defendant, which I have honestly never seen before, where even our decision-making and what we're filing is being impacted by the media attention on this case. And I'll yield the rest of the time to the state.
All right, State.
Thank you, Your Honor. I want to respond to a few points made in her motion first, and then I will argue the law in this case. Your Honor, counsel referred several times to
affidavits that she attached, which is a requirement under the statute. I would just point out that there were only 2 affidavits presented, from which they're not limited. They could present as many affidavits as they wanted from members of the community, and one of those affidavits is actually from a retired former member and attorney with the Public Defender's Office. So those are the 2, there's 2 affidavits presented in support as far as evidence from community members as to actual opinions. As to the comments that are touched on in 4 sub C and the comments made on Sheriff Hardwick, council attached about a 5-page transcript of, and it looks like a segment that aired on TV with Katie Jeffries and Sheriff Hardwick and some others. It's 5 pages long. Sheriff Hardwick doesn't say anything inflammatory in that interview. He's asked if any other charge, it's very early on. And I think even though it's not dated, you can kind of tell it's early on because he's being asked if he believes anyone else is going to be charged. And he says, no, I believe we have the correct person and no one else is going to be charged. Because counsel made an argument in here that he's commenting on his guilt. Well, he was just saying we have the one and only person that is going to be charged. There's nothing inflammatory in Sheriff Hardwick's interview, and that was the only one that she provided to the court. A large amount of the memorials and everything that she cited in Defense Exhibit 7, if you look at the dates, those all occurred within a week of the homicide, all of those events. Funerals, vigils, and other things mostly occurred within a week of the homicide, and there's no evidence as to the number of persons that obviously attended those. I am certain those questions would be asked in a jury selection. She's asking them also in deposition to see what witnesses participated in what community events, which obviously could play a part into jurors that are selected or not. The teal ribbons, I think those have been isolated to the northwest part of the county. To be quite honest, I've never seen one south of the courthouse. Here in this part of the community, we have a large county. It does appear that those ribbons and things like that are exclusive to our northwestern quadrant of the county. And she's asking members about the ribbons and participation in these things. She's asking the witnesses that are in deposition. And yes, a lot of them are involved in these. Well, there are people very close to the case for one reason or the other. They're classmates of Tristyn. They're neighbors and friends of Tristyn. They're teachers. So it's not surprising that the witnesses in deposition have attended those things. And I don't believe that's an accurate representation, obviously, of our population as a whole. Mr. Larizza's comments, just quickly. I believe the only press conference, if counsel has evidence to the contrary, is the very first press conference that was done after indictment in May of 2021. Mr. Larizza made a comment as to the number of stab wounds, which obviously was immediately public record as soon as an autopsy report was published. I highly believe that the media would have covered that information, whether Mr. Larizza said it or not in a press conference. So he mentioned the number of stab wounds. He mentioned, she cites in here, statements that Mr. Fucci made to friends that may lend to premeditation. Also information that all under public records law had to be given to the media. I think Mr. Larizza used the word horrific, and that was all to describe the crime. As far as inflammatory things that the court can take into consideration, that was the only sort of descriptive word in that press conference. And Ms. Peoples is commenting on Mr. Larizza and Mr. Hardwick and their constant, which I don't believe the evidence supports constant, comments on this case and in interviews and on social media. As to the state attorney's office, we have a Facebook page. It was created in April of this year. It has 930 followers, and we have never commented on our Facebook page about this case. What is interestingly lacking in this motion, and I believe, and as it's common knowledge, it should be mentioned, is the Public Defender's Office.
All right, hang on, chat. Listen to this. this is the part that I kept referring to in regards to this weird, unprecedented move by a public defender's office. Okay, so pay attention. They are trying to get a change of venue because they're blaming all this media attention, all this vigils and funerals and all these things. Listen to what is about to be revealed. This sounds very intentional in order to get a change of venue. This is the most bizarre shit I've ever heard. Here we go.
Earlier this year, hired a company to do polling in this county. So the public defender's office, not the media, not the state attorney's office, not the sheriff's office, hired a company to personally reach out to every voter in this county to seek their opinion on this case. Now that information is not in this motion, but that's actually individually drawing attention to this case of potential jury veneer that may not have known about it. Those were actions by the public defender's office. So I wanted to mention that because I don't think it should go unnoted as far as that was a personal reach out by this office to gauge opinion that now is not included in this motion. As to the change.org petition, I just wanted to point out there's 9,000 persons in St. Johns County that got involved in that. That is approximately 3% of our population. And Your Honor, so just responding in that way to, so there was a change.org petition that was St. Johns County residents, people that self-reported, only 9,000 on the whole petition. And then I'm comparing that to our population, which is about 3%. And that petition was to encourage our office to charge him as an adult. So Your Honor, I know you're aware of the law, but I just would remind the court, our position is obviously that this motion is premature and there has been no great presumption presented of partiality against Aiden Fucci. There's a two-pronged test that Your Honor must consider and rule on in making a decision on a change of venue. And one is the extent and nature of any pretrial publicity, which we've been touching on now. And two is obviously the difficulty encountered in actually selecting a jury. So that's why this motion is premature, and there's been no overwhelming presumption of partiality shown to Mr. Fucci that would take the court's analysis out of the case law on this subject. When you consider the extent and nature of pretrial publicity, there's a number of factors the court should consider. One is the length of time that's passed from the crime to trial. If we still proceed in February, it'll be about 21 months since the crime, the homicide, to trial. The other thing, Your Honor, is to consider when reviewing the attached articles that counsel's provided is whether the publicity that occurred consisted of just straight factual news stories or inflammatory stories. I've reviewed, it's hundreds and hundreds of pages that she provided. A lot of it appeared duplicative, but a majority of them seem to be centered around, especially that had to do with the facts of the case, were centered around that May, June time period once he was indicted. It's information about his location, the cause and manner of death, and things like that. What it seems to have occurred after that, like counsel said, is reporting on court dates and motions that were filed. But in May and June of 2021, as we released discovery, things were commented on. But since then, it's largely been about court appearances and the progression of the case. Another factor is whether the news stories consisted of police or prosecutors' version of events to the exclusion of the defendant's version. In the beginning, there was actually a lot of coverage on the statements Aiden Fucci did make initially. He didn't ultimately give a statement to law enforcement in an interview setting, but his initial statements, his initial denial, his Snapchat videos were put out, his statement to the first responding officer that he walked with her home and he left her. That's his version of event as far as the state has in its possession, and that has been put out to the media and also covered on. And then, Your Honor, another factor is the size of our community in question. And obviously, we are a very, very fast-growing community. Your Honor was right. The 2021 census data that Ms. Peoples provided showed in June of 2021, so over a year ago now, we were at 292,000 residents. We've had a 44% increase in 10 years, and we're the second fastest growing county in the state as of last year, and one of the largest in the nation. So we are constantly, in the last 21 months, getting a new influx of citizens in our county, and I think that should be considered. And then in the analysis, obviously, of the publicity is whether the defendant had exhausted all of his peremptories. So everything in your court's analysis has in mind the attempt to pick a jury. And when you review the case law, the courts are mindful of when courts are very liberal with allowing, additional peremptories, very liberal with the cause strikes. Obviously, I know the court, I picked juries with the court and counsel, and I know that everyone would be very cognizant of the pretrial publicity, and cause strikes would be, I'm sure, liberally granted if there was a need when selecting a jury. And so I had emailed, Your Honor, some of the case law that all outline this test, and they outline how difficult or not it is to get a jury. I would just comment on a few cases I sent over. Copeland v. State, that was a case in small rural Wakulla County where a 19-year-old waitress was murdered. And they talk in that case about, obviously the question is not whether jurors can put matters out of their mind and try a case, or the question is whether they can put what they've heard out of their mind and try a case solely upon evidence in the courtroom. They commented in Copeland that every single member of the jury veneer had heard or read something about the homicide, but that did not require or disqualify them as jurors. In Rowling v. State, Your Honor, which is a Danny Rowling case where he killed 5 UF college students, obviously extremely high-profile case, and they again comment, State acknowledged massive media interest, but argued that again, it's been straightforward news stories talking about facts of the case, nothing inflammatory. The court took extraordinary measures to ensure jurors that were sat were fair and impartial, and the court reminded us that jurors need not be totally ignorant of the facts of the case, nor do they need to be free from any preconceived notion. That would be an impossible standard to apply. People are going to have even initial preconceived notions. The question is can you genuinely pick persons that can set that aside and only rely on what they've heard in court and not maybe what they've heard in the news? That's the standard. And then again, lastly, Your Honor, I just mentioned DuBose v. State, which is a Jacksonville case where a little 8-year-old girl was killed by DuBose and some of his brothers. I mentioned that one simply because they specifically cited to some of the inflammatory comments by a Jacksonville Sheriff's Office representative. And in that case, someone from the Sheriff's Office in the media would refer to the DuBose brothers as miscreants, a menace to society, constantly say their behavior was despicable, stated they were in the right place in jail, and there have been some of those articles and interviews, and the court said that those remarks did not require the case to be moved. It didn't qualify for particularly hostile or inflammatory. So again, our position is that this motion is premature. We should have an opportunity to attempt to select a jury in this case, and there's been no presumption of partiality shown against Mr. Aiden Fucci.
Thank you, State.
Just briefly, Your Honor, the 2 of the cases that the state has provided are from, I believe, 84 and 94, and don't take into account the 84 and 94, and don't take into 84 and 97, not taking into account the impact and the effects of social media, which we have in this particular instance. Turning to the most recent one is a 2017 case of DuBose. And as the state mentioned, the issue there is the local prejudice of an officer. It wasn't the sheriff, and it's not an individual that carries the weight of Sheriff Hardwick. So There has been some time since this offense. The offense date is May of 2021. But the attention continues. Even on the 28th of November, Sheriff Hardwick was commenting on the motion in local media on November 28th about the motion to change custody. It was just 2 weeks ago. So we're still having commentary by the local sheriff on this case that's impacting the views and opinions of the community. The statements of, and I know it's in here, but just to be clear, the statements of Larissa is that it's premeditation, could only be inferred. And then he describes the numbers as 114, and then he goes on to describe the stabbing action within the video. And just the fact that she had been, I'm quoting again now, just the fact that she'd been stabbed 114 times, 14 or 114 times, as a reason why this is premeditated murder. That's the elected state attorney. So we have an issue where the publicity is great. And the distinction was drawn with the 3 cases that are all out of St. Johns County, of Kevin Williams and Collie Williams, and the third, and it'll come to me in a moment. With these 3 cases, Your Honor, we had local media coverage that totaled about 15 articles. And even though we only had about 15 news articles from those cases, the impacts of those cases are still with us today. The Collie case caused changes on the way the schools were operating and releasing children. The Collie case impacted this courthouse in terms of how we handle first appearance. The questions that we now ask in first appearance and whether or not an individual has a GPS monitor is directly tied to the impacts of the Collie case. That's here in St. Johns County. 15 articles, again, cumulatively between the 3. The Williams case resulted in new legislation and how we sentence individuals who are charged with harming or causing the death to an individual with certain disabilities. In particular, I believe that the decedent in the Williams case was autistic. And we had, again, at best, 15 articles between these 3 defendants before the case actually goes to trial. And then the Quentin Trudeau case, which was part of a death penalty case with 3 individuals that spanned the jurisdictions from Gainesville through St. Johns County.
Louisiana.
Right. The defendants from Louisiana, but the decedent from Gainesville. Thank you.
Wrong college.
You're right. But the point being that we're looking at a stance of communities and individuals being in fact impacted by Quentin Trudeau and the other defendants. And again, with these cases that had major impacts on St. Johns County, the pre-trial publicity was minimal. Yes, the media was there. Yes, the media reported, but nothing to the extent that we're seeing with Aiden Fucci. So the question that the state rightly posed, based on the case law, is not just the time that has passed, but the publicity that has occurred and is still ongoing, with facts pertinent to this case, as alleged by the state, that haven't been produced in front of a jury. Police opinion and state attorney opinion, and even statements by the defendant that may or may not be presented in trial are well known within St. Johns County. So, rightly stated, we have not exhausted any peremptory challenges. We have not, because we haven't even started to pick. But this is a unique situation, unlike Colley or Williams and Trudeau, where we have a defendant who is seeing significant impacts on his ability to pick an impartial jury based on the media coverage, based on the statements of individuals that carry weight in the community. And yes, one of those certificates is from a former public defender on the southern side of the county. Because a moment ago the state mentioned that all these ribbons are on the north end, but the impact of this case is seen throughout. And I will say, yes, there are more ribbons on the north end of the county, but they're on the southern half of the county also. They're throughout. So I'm asking the court to, and we will respond to the questions of the court and provide some of the commentary from the individuals online. But we're asking the court to allow Aiden Fucci his constitutional right to a fair trial and not have it tainted by the politicians in this immediate community. See, the well in St. Johns County isn't like it is of jurors. It's in the sense of Dade or Broward, where we're dealing with millions. And yes, the numbers are growing, and yes, we have individuals coming in from out of state, but the media attention isn't changing on this case. So even there's new people coming in, the new people are also being exposed to the same media coverage. So the potential well of jurors in this county has been tainted by sheriff and by the state attorney, R.J. Larissa. And the best protection at this juncture for Aiden Fucci is greater than just the peremptory challenges. It's moving the case out of the circuit and out of the attention of the Jacksonville media. That from what at least from what I can see, it goes down as far south as about Palm Coast, which would be Flagler County. So with that being said, we're asking the court to change the venue, allow him his constitutional rights to a fair trial. And in terms of the polling, as another example of defense counsel or the team holding back on certain things because of the media attention in this particular case.
What effect did that have on your motion? The polling?
The
Was that
polling,
in fact sent out to every single registered voter in St. Johns County?
don't perfectly know, Your Honor, because it was only by email address and we didn't have everybody's email address.
Let me just ask you, I mean, I think we can agree that there's certainly been a lot of media coverage, but there are people, believe it or not, no offense to our media folks here, a lot of people who don't really watch or pay that much attention to the local media. But by sending an email, now we've actually reached into their computers, right? And so now they're receiving information that then may have triggered individuals who may not have been aware of this to then perhaps do some research into it or start paying more attention to it. Did you calculate that risk in making that decision?
Your Honor, I know this is new for St. Johns County, but it's not uncommon for, and I think the Cooey case it did not happen, but it's not uncommon for defense attorneys when you're doing a change of venue to poll the community to get the views on the community as an assistance or a factor as to whether it needs to be changed. And yes, there were a few in the minority who were not aware of the case. There were a few, and I mean a minority. The majority of the individuals responding were in terms of this individual can't get a fair trial and details about the case or things like that that were being responded to.
Your Honor,
So-
I'm gonna ask that that not be considered. It was not included in her motion,
It
which
was not,
there
the
are
state brought it up.
questions as to why it would not be, and we've not been provided that data to be able to respond if that's actually the sentiment. I believe if that was the sentiment, it should have been, it would have been included.
So I'm just responding because the state did bring it up. So in terms of whether it's the polling data or motions, that there are impacts on how we're approaching this case that I have not experienced before. So again, and that would come back into effective assistance of counsel, that it's affecting our defense of Aiden Fucci. That what we say and do is being reported or misunderstood or misconstrued. And yes, there's always that opportunity in trial, but if we moved it out of this jurisdiction, dealt with a jury pool that was unaware of this and doesn't have the impact of this case that we're seeing in this community that are great. And that's what we're asking for, is that he's allowed this opportunity to a fair trial and that we cannot do that in St. Johns County.
I'm not going to require you to follow up on those other matters because I think at this point I'm just going to go ahead and rule. I'm going to deny your motion to change venue at this time. Obviously, it's done without prejudice, and as we
work our way through jury selection. Certainly, if it becomes clear that we're unable to select a fair and impartial jury here in St. Johns County, then obviously we will have to revisit this. But at this point in time, the court's going to deny your motion. We have one other matter on the calendar for today. You want to go ahead and address that at this time?
Your Honor, it's just a motion to ask the state, without whatever mitigating circumstances they have, that they.
All right, we're going to be done playing that. And I'm going to play one more video, and then we're going to end the stream because this is just I'm going to play one more video, and then I'm going to tell you guys quickly about the Kenosha wrongful death thing, just to set you guys up for what we'll do in the future. But, you know, this stream was just about background details. So again, jury selection is expected to start Monday morning. I'm hoping that by tomorrow there will be some articles that are out that give us a time that this is going to start so that I know ahead of time and getting the stream set up and all these things. So we'll see. Let me get this other video for you guys. This one's short, guys. It's not long. Not long. So this is talking about, how, you know, we heard that he's fighting and all these things. He's in solitary confinement now. So this is some motions about how solitary confinement is torturous and all these things. And the defense is is going to be put to the test here. The state is going to be like, okay, here's an option. If you want to go ahead with this option, then great, we'll do it. So listen to this. So it's kind of interesting.
I understand the court cannot instruct the sheriff on how to house the defendant. I understand that. But I can't sit by and say nothing when I know that this is causing a detriment and a harm to the defendant. So solitary confinement, this isn't a new, it is not a new thing. It's ancient, it's been around for millennia, but the science on it is a couple of 100 years old. Science meaning that it's been observed and repeated, and an analysis and a rate and study of it and its effects is well documented. The harm of solitary confinement is well documented, whether we're looking at psychology or psychiatry, that this causes a very real, very measurable harm on adults. It also is, that's what's within the exhibits are examples of different branches of science, of medicine, calling for the cessation of solitary confinement. Why? Because we know it harms adults, we also know it harms children. And these studies are looking at harms that exist after 48 hours of solitary confinement. This particular child, and yes, I know he's a defendant, an adult by the court's view, but this child has been sitting in solitary in its forms cumulatively over 400 days. Now, in first instance, it was for his protection because there was concern for suicidal ideations. And then on the second instance, it was concerns of harm to others, and then threats to himself. Now, a lot of these threats are born because of the media attention to the case, so his name is well known. In Duval, this case is well known also here in St. Johns County. But there are other counties that he can be housed in, and it has been that I've seen with my own experience where defendants are moved for their protection. Whether they're moved within the circuit or outside the circuit, it is not uncommon for defendants to be moved, where sheriffs will trade defendants to keep that individual safe. But that option hasn't been practiced in this particular instance. What's been done is that he's been held without an ability to congregate or meet with other individuals, without eye contact with other individuals for an extensive period of time. So the worst form of solitary that's out there would be no sight, no sound, and that's not what he has. meaning he can see other officers because it will bring him food. But it's still a form of solitary confinement. And solitary confinement, whether you're looking at psychiatry or psychology, is a form, or its results, is a harm that can only be considered a punishment. If you look at a case like Chambers v. Florida, and this is from 1940, that the technique of solitary confinement was considered at that point as a form of mental torture or physical torture the government used to coerce confessions. So it's not a debate or a question as to whether or not it's a form of torture, because it's well recognized within the law. If we're looking at United Nations, it is. Is it permissible in the state of Florida? And again, I have to say, yes, it is. The case law permits it. But the issue is that we're now looking at a child that is being tortured in this form of solitary confinement. Although it is legal, he's still being tortured and punished when he hasn't been convicted. He hasn't been tried. No jury has been sworn. He hasn't even entered in a change of plea or a guilty plea and moved forward towards a sentencing. And for that reason, I'm bringing the court's attention to this and asking that consideration be made for alternative housing. Again, the court cannot tell the county jail to move him or tell the sheriff, because the separation of power is very clear. All that I can do is what I'm doing, and that's ringing the bell and sounding the alarm as to what's happening to Aiden Fucci. We've been in contact with the sheriff, St. Johns County Sheriff, and with the Duval County Sheriff on this issue. And there's been no change. And I've provided the case law. I've provided the rules that they're relying on for this detention and the legality of it. But again, we can't ignore the harm of it in light of alternatives. Duval County Jail is not the only jail in the state of Florida. I am unaware as to why he was moved there, and they don't have to disclose that, being the St. Johns County Sheriff's Office. But there are other county jails he can be moved to. And that's what I'm asking for consideration, that there are juveniles held in other locations in the 7th Circuit and beyond. So right now he's been moved out of the 7th Circuit into the 4th at Duval County Jail. That's the 4th Circuit, and we're asking for consideration of his transfer to another location that would be safe and humane. And that's not to say that the intent of the Duval or St. Johns County Jail is not his safety. It's my understanding he's there for his safety, but at the same time, this measure to protect him from other inmates is causing a harm. A harm that, whether, whichever branch of science you're looking on, is well documented and well known. It is not a new thing to say that solitary confinement causes harm to an individual. But not just in the state of Florida, but in this country, in the United States, it is a very legal form of detention. It is. I cannot say it is not. I know that the response from the state is playing into, or drawing light to, the separation of powers and the right to do that. But I must do something, Your Honor, and all that I can do at this point is provide these articles in support of the harm that solitary confinement causes adults, the harm that solitary confinement causes to children, and ask that some other placement be provided. That whether or not the jail will not place him outside of solitary Duval, and clearly they have no intention to do that, that consideration be made to place him in another county where he doesn't have to sit in solitary for this extended period of time, where he hasn't been convicted. Most of the case law in favor of solitary confinement is post-conviction. There's been no conviction in this case, Your Honor. So with that in mind, I ask the court's attention to this and I'll leave it to the state.
Thank you, counsel. Ms. Duffy, do you wish to be heard?
Your Honor, no, the state attorney's office will defer to the sheriff for the defendant's care, custody, and control.
All right, very well. Ryan?
Your Honor, I'm trying to follow the defense's position. They're essentially stating that they use the word torture, and in their version of torture, that means being kept in a facility where he's safe. I haven't heard anything, and I suppose there's an argument to be made that because he doesn't have more interaction with other inmates, maybe more rec time, that somehow that is a version of torture. I haven't heard an argument that suggests that putting him in another location or another facility would be any different, or this classification would be any different. The sheriff does agree with the defense's position on the law. In the defense's motion in numbers 12, 13, and 14, that is a correct statement of the law and the separation of powers of issue that does exist. But as far as this torturous, conditions that Mr. Fucci's currently residing in, the sheriff takes issue with that. At this time, I'm going to call a witness and maybe enlighten the court as to what his actual conditions, his living conditions are in Duval County. So at this time, if with the court's permission, I'll call a witness.
All right, who is your witness?
Director Tara Wiles.
All right, Ms. Wiles.
Your Honor, if we could have a brief answer. I was not aware that the sheriff was calling a witness.
That's fine. If you'd like to speak with her for a moment, I'll open that up.
And Judge, I'm perfectly fine not calling a witness. This seems to be more of a legal argument than a factual argument. And if we want to just keep it based on the law, the sheriff's perfectly fine with that.
All right, well, why don't we just keep it at the law then? We'll take it to the law. I think we all agree on what the law is and where my hands are going to be tied to the law. So I don't necessarily know it's necessary for me to hear from any witnesses. However, I think it's important for us to all be working together to make sure that we're finding the least restrictive means to house him. And I'm confident that everyone is aware that that should be the priority, and I believe that is. But I'll certainly.
Judge, I think that the responsibility of care, custody, and control is an enormous responsibility, and it's a burden on the sheriff, who is the defense rightfully suggests in their motion. He is the chief jailer of the county. The only proposal I could possibly make is if the Office of the Public Defender wants to take responsibility of Mr. Fucci's care, custody, and control, then they can have a seat at the table and they can decide where he would reside up until trial. And then at that point, we'll certainly listen to any suggestions they may have. But I'm not aware of a situation or any history where the Office of the Public Defender or any defense attorney is willing to accept that responsibility, because it is a huge burden.
Is the sheriff suggesting an RR form, or?
No, the sheriff is suggesting that if the public defender is willing to be responsible and liable for Mr. Fucci's care, custody, and control, then they can have a seat at the table and decide where he resides up until trial. But up until that point, the law clearly states that is within the sheriff's purview.
Well, here's my ruling. Do you wish to be heard anymore? I don't think obviously that's going to be. You're going to accept that invitation.
Just for clarification,
Sure.
Meaning if the defense accepts the responsibility, he would be released? I just want to say,
I'm not sure what exactly is being proposed, but the bottom line is this: I cannot release Mr. Fucci to anyone, and I won't release him to anyone at this point. He is going to remain in custody of the sheriff and continue to be the responsibility of the sheriff. So his care, custody, and control is going to be in the sheriff's hands. I have to deny your motion. I think you understand that. I believe that as you've already stated, there is a clear separation of powers here, and it is the sheriff's responsibility to maintain his care, custody, and control, and I cannot order the sheriff how to go about that. However, I will reiterate that I expect that the sheriff and anyone else who is involved in this process continues to listen to your concerns, and if there are less restrictive means or some other alternatives or something that permits him additional
time outside, whatever the case may be. Clearly, we are dealing with an individual who is still 15 at this point. I'm not even sure. 16 now. We need to all be aware that a prolonged term of solitary confinement would have an effect on anyone. So I'm going to ask that we continue to make sure that that is the least restrictive thing that can be done. If there's other alternatives, I would just ask Ms. Wilds and everyone else involved. I see them shaking their heads, and they will continue to do that, and they will continue to make sure that he is properly being taken care of while in the custody of the sheriff. Ms. Peoples, I assume that you have Mr. Klein's number. I'm sure that he will be happy to receive any calls. Ms. Wilds, I know as well, would probably be responsive if there are concerns, continued concerns, let them know. We are set for trial in February, so we are getting close. So hopefully we'll have this resolved one way or the other fairly soon anyway. And we will, I know that we're going to continue to make sure that that trial date stays in February so that we can, figure out what to do next from there. Okay, with promotion.
All right, so that is that. They were trying to argue about torturous conditions pertaining to solitary confinement, and the state called her out and said, look, if you want to take custody of Aiden Fucci, you want to provide housing for him, secure housing, then come sit down and let's figure it out. But if you're unwilling to do that, then he's going to stay in the jail. So that is that. That is about, I think, extensive enough detail kind of coverage about what's happened in this case thus far. I don't think we need to play every single motion hearing and everything that has been done since 2021. Obviously, there's some sound issues with some of these videos, which kind of sucks. I am expecting a better stream when this trial starts. Jury selection scheduled for Monday morning. Again, I have yet to find an article stating what time jury selection starts. So I find that a little bit odd, considering the fact that every media outlet has said that this is starting Monday morning. So it is weird. Obviously we would imagine 8, 9 a.m., but there's time differences between Florida and Wisconsin. So we need to know an exact time. So I'm hoping that by tomorrow there might be something more definitive. If you guys find a time, let me know, shoot me a message. So here's kind of the schedule. Obviously things are fluid, things change with me very rapidly. We're probably going to start doing some live streams at 7 p.m. Covering some Kenosha stuff. So we're going to try to limit it to 3-hour streams. This way it's done by 10, maybe 10:30. I don't want to go longer than that because otherwise it's late into the, morning hours, and that's ridiculous. But probably about 7 p.m. We'll do some Kenosha streams. Over the weekends, I'm going to be focusing on what I normally do. Articles, getting some videos up on the YouTube channel, kind of doing all that stuff during the day so that we can do some weekend streams and weekends kind of maybe starting 6, 7 p.m. and covering Kenosha 2020 unrest. Now, here's the reason why we are doing this. So in 2021, I told you guys, some of you have asked, I told you guys before, and yesterday this was talked about again. people were asking me about my opinion on Kyle Rittenhouse and all of these things. And I've said numerous times, there are certain things I can talk about and there are certain things I cannot talk about because I might be called as a witness. And we said that there's some lawsuits that are still running around out there. I don't know if I'll be called as a witness. They named me as a witness for the trial. I was never called. They didn't even use my footage. They didn't call a lot of us as witnesses. Primary people that were there, they didn't even call us. So I don't know what's going to happen with the lawsuit stuff. It's still kind of in some, I don't want to say early stages. We're kind of in the middle stages at this point. So I have been contacted by the attorneys because of the amount of video footage, documents, audio, the amount of stuff that I have in our possession here at Never Stop. That's about all I'm going to say on that. We have been contacted. I do not know if I'm going to be called. With that said, when we start doing these streams, you guys can expect the chat to get real spicy. Okay? It's going to be fucking insane. My mods are going to be very heavily on top of things. People are going to be getting banned. Comments are going to be getting removed because there's a lot that we don't allow when it comes to talking about Kenosha. Okay? Celebrating people's death and all of that shit. We don't fucking allow that. There's going to be a lot of misinformation and disinformation comments that are fucking removed. If it is not a factual comment, it's not coming on this platform. Okay? The purpose of streaming this stuff now, again, is to put out real factual information because there's so much bullshit rhetoric that has gone around over the little over 2 years. You know, the thing is, I don't care what side you guys are on. I don't give a shit if you're pro police and pro militia. I don't give a shit if you're pro protester. Okay. That's all fine. But we need to have an environment where we are focusing on the truth because there's already bullshit that's gone out since yesterday again. One of our, it's friendly enough, but we still call each other rivalries, has posted a video today where there's already disinformation that they stated. We're friendly enough and we've done some arguments about this shit, but I saw it today. I commented, you know, about him putting disinformation out again. So I don't care what side people are on. Okay. We got to keep the chat real fucking crispy. And you know, certain comments are going to be blocked. Boss, I already have Jess over there. So it's not a big deal. We got Facebook taken care of. Just, I need you here. All right. So the reason we're going to be doing this, and I don't want to be sitting here for a long time talking about this because we were trying to focus on Aiden Fucci, but I just want to bring this up real quick, let you guys know kind of what's going to be happening. So this wrongful death lawsuit against Kyle Rittenhouse for the death of Anthony Huber, okay, was filed in 2021. Okay, so the father of Anthony Huber filed the lawsuit in 2021 accusing, and this is very important. This is very important. The verbiage that is here. I'm going to be putting the lawsuit up on the Facebook page so you guys can read it. Okay, it's fucking 38 pages. All right, we'll talk about it. We'll break it down when we do the Kenosha streams. But if you guys want to read it yourselves beforehand, I'll get it up on the Facebook page today. Okay, we've been sitting on these documents. There's one for Gage as well, but that's not being talked about yet. But the verbiage in these documents is going to be crucial. And if you've listened to me in the shit that I've said before talking about Kenosha, okay, we have a lot of proof. Never Stop Media has a lot of proof of accusations in these documents. So accusing officers of allowing for a dangerous situation that violated his son's constitutional rights and resulted in his death. Okay. That sentence, allowing for a dangerous situation. I'm going to take this as the totality of what happened in Kenosha. And we have put out proof that officers did allow a lot of bullshit that shouldn't have happened. There was no need for any of Kenosha to go down. Anthony Huber's father, John Huber, also alleged that Rittenhouse, who was 17 at the time of the shootings, conspired with law enforcement to cause harm to protesters. That's going to be a key thing. It's going to be key. That sentence right there could fuck this all up. Okay? I have not found any proof that Kyle conspired with law enforcement. I've found none. I don't even think that's fucking factual, personally, but I've not found any proof to prove or disprove. So I can't definitively say one way or the other. But as of today, right now, with the thousands of documents, the hundreds and hundreds of videos, I think that's a fucked up statement. I've not found that. I've found other situations of conspiring, but not with this kid. So that might fuck a lot of things up. Now, conspired with law enforcement to cause harm to protesters. John Huber is seeking unspecified damages from city officials, officers, and Rittenhouse. That's pretty key. U.S. District Judge Lynn Edelman on Wednesday, so this is yesterday, that's why we're talking about this, dismissed motions filed by Rittenhouse and the government defendants seeking to dismiss the civil rights lawsuit. In allowing the case against Rittenhouse and the others to proceed, the judge said that Anthony Huber's death could plausibly be regarded as having been proximately caused by the actions of the governmental defendants. So again, some key verbiage is there. We can prove, and we have, Never Stop Media has already proved that law enforcement caused these situations. We proved that law enforcement conspired with militia. That was out there. This is factual. We've proved it. Okay. But I don't think the Rittenhouse conspirement is fucking accurate. I just don't. But again, we still have 25 agencies to file on. So there may be some hidden shit. We don't know. Rittenhouse attorney Shane Martin said in a phone interview that it's important to note the ruling doesn't address the merits of the case. It only allows it to proceed to the next phase. So we kind of talked about the merits. We'll get into all this stuff, guys, when we do the streams. While we respect the judge's decision, we do not believe there's any evidence of a conspiracy, and we are confident, just as a Kenosha jury found, Kyle's actions that evening were not wrongful and were undertaken in self-defense. So naming him specifically, that he specifically conspired with the government, this could fucking tragically derail this entire thing. You got to be careful in the verbiages in your motions and briefs and all these things that you file. Little discrepancies like that are problematic. Now, attorneys and private investigators for John Huber spent over 100 hours trying to locate Rittenhouse, tracking down addresses in 7 states before they found the home of his mother and sister in Florida. So Wendy and one of the daughters, they're living in Florida. The lawsuit was served on Rittenhouse's sister, who said that he wasn't home. Edelman said that was sufficient to qualify as being served. Rittenhouse had argued that the case against him should be dismissed because he wasn't properly served the lawsuit. Edelman dismissed that, saying that Rittenhouse is almost certainly evading service. Interesting. Now, we know the kid is on a press tour again. Okay? So, but does he live in Florida with mom and the sister? Or is he with his alleged PR person, who is not a fucking PR person? Deeper roots than that. Rittenhouse has been deliberately cagey about his whereabouts, Edelman wrote. Although he denies living in Florida, he does not identify the place that he deems to be his residence. Attorneys for law enforcement and government officials being sued did not immediately return emailed messages seeking comment. The rulings put Anthony Huber's family one step closer to justice for their son's needless death. The Kenosha officials that created a powder keg situation by their actions tried to claim that they cannot be held accountable for their unconstitutional conduct. That argument was soundly rejected today, which was said in a statement. Now that's important. Law enforcement acknowledges their unconstitutional conduct. Okay? And they're saying that while we were unconstitutional in our behavior, we cannot be held liable. We're going to break this down. We're going to get into it. Rittenhouse was charged with homicide, attempted homicide, and reckless endangering for killing Anthony Huber and Joseph Rosenbaum and wounding a third person, Gage Grosskreutz, with an AR-style semi-automatic bang-bang in the summer of 2020 during tumultuous night of protests over the shooting of Jacob Blake by Kenosha police officer Rustin Shesky. Rittenhouse was acquitted of all of those charges in November 2021 after testifying he acted in self-defense. Rittenhouse's actions became a flashpoint in the debate over bang-bangs, vigilantism, and racial injustice in the U.S. This is how the sides went fucking absolutely bizarre. Rhetoric, politicizing a tragic situation, right? Lies, misinformation, disinformation. It ran fucking rampant. Things were used to advance politicians' careers, get them reelected. Insane. Rittenhouse went to Kenosha from his home in nearby Antioch, Illinois, after businesses were ransacked and burned in the nights that followed the Blake shooting. He joined other armed civilians on the streets, carrying a weapon authorities said was illegally purchased for him because he was underage. Rittenhouse first unalived Rosenbaum. Then he ran, stumbled. Anthony Huber, 26, struck Rittenhouse with his skateboard and tried to disarm him. Rittenhouse fell to the ground, shot Anthony Huber, and wounded Gage Grosskreutz. His case is one of several ongoing civil lawsuits filed in the wake of the shootings. So I told you guys there's multiple. Grosskreutz last year filed a similar lawsuit against Rittenhouse. Told you. Rittenhouse has maintained a high public profile, particularly on social media, where he is an outspoken advocate for bang-bang rights. He has nearly 1 million followers on Twitter and has spoken at conservative gatherings. So that's that. Just a quick little intro to you, let you know what we're going to be doing. We're going to be watching body cam footage. We're going to be looking at footage from inside the Bearcats. We're going to be discussing my articles. We're going to talk about timelines of who's making decisions, what decisions were made, who's investigating what threats were ignored. We're going to be talking a lot about Kenosha. There's things that are said in these body cams and these different footages that we're going to play that detail specifically conspiracy things. And we're not talking about conspiracy theories. We're talking about law enforcement and militia conspiring together. This is proven. We are talking about the conspiracy theory of intentionally pushing protesters down Sheridan Road to the waiting militia. We're going to talk about that in detail. We've proved that beyond a reasonable doubt. There is no fucking doubt that that is a factual thing that happened. Law enforcement staged that. They planned it. They conspired with militia. Now, whether or not militia actually fucking agreed to all of that is a different story. Okay? We've heard from some of them that they're like, what the fuck are you thinking? Please don't do this. Okay? But we're going to talk about all that stuff. So we're going to be watching some sensitive content. We're going to be watching stuff that has been on our platform for a long time. We are the only company that has this shit. Okay? No other, there's not a single YouTube channel that has the stuff that we have. There's not a single Facebook page. There is nothing. We are the only company that has this. I have taken that much fucking pride in this. Okay? So if you want to help us, we still have 25 agencies to file on. We're estimating that that could cost between $3,000 and $5,000. Okay, not Kenosha's bullshit $150,000 lie that they told Judge Kirkman. We do also have to go back at Kenosha because they still owe me records from the lawsuit that I won. So they're in violation of a court order right now. And that has been since last August. So you know where the links are. Okay. If you guys want to donate, that helps. We got a lot of funds we have to collect, all of that stuff. With that said, I am out. I'm done. I got to go do some video editing, do some other things. We got to get this lawsuit up on the Facebook page. That's why I tell you guys, make sure to cross-platform, like and follow things. Okay. Because we may not be going live on Facebook talking about Rittenhouse. Okay. There's reasons for that. So you're going to have to be put here. Can they put a gag order on you to stop you from talking about an upcoming case? Absolutely. Sure. Maybe. It depends. Are you talking about like this Rittenhouse thing? They can fucking try. Good luck. But we've seen in court cases before that judges have put gag orders on media, preventing them from doing certain things. It's more so when it is revolving about jury things or like sealed court documents, things like that. So the answer to your question is it possible that they can put a gag order? Yes. Now, if they specifically put a gag order on me as a media outlet and me alone, it's very discriminatory practices, and you'll start seeing me in fucking court. And you're not going to violate my First Amendment right to, as press, to talk about stuff. So that's that. Now, I do need to be very cautious about what I say because I could be a witness. Okay. So some of the more abrasive Kevin that you guys see sometimes, right? Have some of that shock value. Okay. We got to tone that stuff down. You're not going to hear me arguing with viewers. Okay. You're not going to hear me cussing viewers out. My mods are just going to take care of that stuff. I need to be very cautious right now. Everything I say can be used in that courtroom should I get called. Again, I have no idea if I'm going to be called as a witness. I have no idea. All I know is I was asked to hand over a bunch of shit to people. I did. And that's what I know so far. If there is a situation where I'm notified that I will be a witness or a potential witness, I then need to have our legal team get in contact because I don't know if this civil thing will be live streamed. It may because of the magnitude of what it is. It might, but normally these civil things, it's kind of rare that it's, live streamed. But if there's a situation about me being a witness, I need to find out on whether or not I myself can live stream, because we might be in violation of, because witnesses are supposed to be out in the hallway, right? And they're not supposed to be talking to people. They're not supposed to be watching the news about shit. So if this happens, I got to be very cautious about what I do. And I may have to go in seclusion and not be watching TV, not be reading articles, right? So I'll let you guys know that stuff. Hey, you'll know when I say we're done talking about the Rittenhouse thing. And I'm going to tell you guys, please, nobody fucking send me any articles. Don't even fucking tempt me to open anything. I'm not going to look at shit. But I don't know right now. I don't know how that's going to unfold. We'll see what happens. But yeah, we'll answer questions, when we do these things, when we do these streams. Okay. Let me see what's happening for the next few hours. I may do a 7:00 stream tonight and we'll start talking about these things because there is a lot to cover. So we may start talking about this stuff. We're going to watch a bunch of stuff together. Okay. We're going to watch a bunch. We'll answer questions. We're going to be very heavily controlled on the chat. Certain words are going to be banned. I got to set all of that shit up more than I already have. and all of that. But again, I don't care what side you're on. I don't give a shit if you're a pro Kyle person. Okay. We're not going to have no fucking Kyle's a fucking hero conversations. We're not allowing that. However, I don't care if you're pro Kyle. I don't care if you're pro militia, pro police, pro that side, or if you're pro protester. I don't give a shit about any of that while we're discussing this. I want you guys to have a platform that you know the fucking truth, because there is about to be a mass wave of misinformation and disinformation going out again. Okay? And you guys are going to be getting real fucking confused about the bullshit that is being spread. So if you want to know truthful shit, come here, because I have the most information about Kenosha. Nobody else has it. All right. So with that being said, I'm out. I'll need to know the banned words in advance. Yeah. Look, if your comments aren't showing up, you said some stupid fucking word that we're not allowing. So, but yeah, so here's what we need help with. Okay. We need to get the fucking phone turned back on ASAP, because we need that shit. We need to know Bob Jamboy's contact information. All right. I don't care about his P.O. box that you can find. I'm not writing Bob a fucking letter. I don't have time for that. All right. I want emails, addresses, phone numbers, whatever, but we obviously need a phone to be able to call him. I really want to try to get Bob on. Okay. Bob is doing media shit and he's got some shit lined up. We have an opportunity to get him, but we need to be able to reach out to him. So I'm having a problem. I can't find it. I'm doing 40,000 fucking things. I know you guys like to help with this stuff sometimes. So we need help with that. Okay. We need help with, Kenosha videos. Okay. I know that there are Kenosha videos that have never been released. I've seen a lot of them, but not enough of them. I need to see some of this stuff. Okay. We need, with this trial, this Aiden Fucci trial, its jury selection is supposed to be starting Monday, unless by some miracle this defense attorney convinces the 5th District Court of Appeals that, there's an emergency here and the trial has to be delayed. I don't even think that's going to happen, but if it does, then the trial may be delayed. But as of today, right now, the jury selection is scheduled for Monday morning. We just don't know what time. So be on the lookout for a time, okay? Be on the lookout for stuff that says that the jury selection will be live streamed. Just because they're not banning cameras doesn't mean it's going to be live streamed. It could be pre-recorded. So be on the lookout for that stuff. And please let me know. I'm going to be looking too. But if you guys see it before me, shoot me a message on the Facebook page. Let me know. Okay. We need to know what time we got to be here live. All right. If they're not going to be live streaming voir dire, I'm not going to sit here and fucking go live. This isn't the Jensen trial where we've got a bajillion hours of footage that we can waste time with each other and analyze. Okay. I've shown you guys everything you need to see in this stream. That's the gist of it, summed up as fast as we possibly could. Okay. If you missed stuff, you came in late, started from the beginning, all that stuff, the details that we have there. Okay. So, but we need to know a time and if they are going to be live. I don't even know if Court TV has the contract because I can't call my fucking Court TV buddy. So, again, Court TV gets the contracts for all the cases, people. It is Court TV. No other fucking place gets the contract. It is Court TV. And then Court TV gives the feed out to all the other media outlets, including fucking Law and Crime. And fuck that channel anyway. Okay? So there's always a law and crime person in there with their laptop to feed it through and all the bullshit. Same with all of the lamestream media. That's why always Court TV's feed is always fucked up, is because there's 18,000 feeds going off of them. And then they have feeds that are remote and whatever. Okay. So we got to figure that out. There's still some details we're trying to find. Okay. But we know this will be covered. All right. And if not by Court TV or whatever, it'll be covered by local media with the same bullshit camera that we have seen in this, and pray to God the sound is going to be better. But I would imagine because of the magnitude of this case that we will have a nice feed The sound will be really good, and we'll all survive, and we'll be okay. So with that said, I'm going to end the stream. I will see you guys. If I do decide to go live later on at 7, Kenosha stuff will be at 7. If I decide to do that, you'll see the setups, on Facebook. Plan to go live at 7 p.m. Notifications hopefully on YouTube. Again, if you guys aren't getting YouTube notifications, some of it is because we're uploading a shit ton of videos. So I try to tell you stuff at the end of the streams or in the middle of the streams, what we're planning on doing. So you guys can look. Just like yesterday, we told everybody that we were going live with this group and fucking nobody showed up. So that's honestly fucking irritating because you guys missed a bunch of really good stuff. But whatever, I guess it is whatever. But that's why we try to tell you guys like, hey, this is what's happening. Okay. We got banned from a fucking Facebook group yesterday over some bullshit fucking lie that somebody in the group told, reported us and said that we were charging people to watch our fucking live streams, which it's not even fucking factually accurate. So I'm not only removed from the group, but I was banned. I can't even see the group anymore. That's why I told you guys this happens. It's hard for us to get into these groups because we're the people that, own this stuff and we're, whatever. So try to get this stuff out there. All of that. With that said, I will see you guys. I'll talk to you on the next broadcast.